We're verifying that it's streaming. Hold on 1 second, Judge.
Okay. Ms. Robinson, do you have another matter?
I do not, Judge. I was just making sure we're good on Strickland to sign off.
Oh, yeah, you are. That matter's concluded.
Okay, thanks so much.
Thank you.
According to YouTube, Judge, you are not live streaming, but according to the screen, you're live streaming. But when we went on YouTube, you are not one of the judges that are live streaming.
Well, I'm not techie, so I don't know what you all want to do, unless you want to call.
I'm calling Stephen right now.
Goodness. We have to apologize, everybody. We're supposed to be live streaming because it has to be available to the public. So,
Judge, can I ask if my client Deja Baker is on the call?
Ms. Baker, are you on the call? There are quite a few people in the waiting room, so.
Oh, okay. All right. Thank you, Judge.
I don't, yes, Deja's phone, I do see her.
Okay.
Good morning, Judge. I'm here to be on the Brock and Wilson case, Judge, but I know that they are in MDOC, and I think that they were writted out for a specific time. So I'm wondering if you might know the time that they're writted out for, and I could come back at that time.
Let me check with Hope. Know what time they're read it out.
Thank you, Judge.
Can you all
Sorry,
hear me?
Judge, who's the person?
In the courtroom, can you all hear me?
Yes, who was the person, Judge?
Mr. Damani?
Yep, that was Mr. Brock and Mr. Wilson. They are in MDOC and they were written out for today for a final conference.
I believe it was 10 and 10:15, Judge.
Thank you.
Judge, are you going through Internet Explorer?
I mean, I just signed on the way Stephen asked me to sign on. I don't know. I'm assuming so. I went to Zoom.
You need to go through Microsoft Edge for Zoom.
All I did was hit the more button at the bottom of the screen. For live. So, I mean, I don't know how I'm.
Judge, make me a co-host. I can do it from here.
The computer on the chambers in the courtroom is a co-host.
Okay, go up there.
So you can do it.
10 and 10:15.
Brock is what?
10 o'clock.
Brock is 10 o'clock.
Wilson is 10:15.
Wilson is 10:15.
Thank you very much. Be back then.
Okay.
I'll be back at 10:15.
Okay, we'll see you then.
Good morning. Do we have Aaron Wortel on the docket?
Let me look and see. Is that with a W? Is that Wartail?
Yes, yes.
I have Wilkerson and Wilson. No, I do not have a Wartail. Is he in custody or out?
He's out, Judge. It's a sentencing date that's been moved. I just want to check with Madam Clerk if it's set for today or some other day.
No, it's not on there for today. At least it's not on the docket. They just scanned over to me, so.
Like I had it on my docket as of last night, and I spoke with Miss Kennedy, and she said that it was it needed to go on record because it was a re-referral still because he absconded from parole.
Well, this is what's going on, Judge. He's in the hospital. He's in Detroit receiving hospital. He was diagnosed with COVID and he's like in a coma. So we need like 30 days, Judge, to find out when he's going to get out of the hospital.
Okay, do you have paperwork to that effect?
No, I haven't received it because I got a call from his girlfriend. He's in Detroit receiving. That's what she told me. And this morning I did text her and she said she's still there in the ICU. He's going to have to provide that once he's out. Once he contacts me, once he leaves Detroit.
Okay, so let me get this straight. He was supposed to be sentenced, but he didn't go for his PSI. He didn't go for the interview in order to get the PSI done.
Well, he was hospitalized, Judge. He was in the inpatient program. Then apparently he was transferred to the hospital for COVID. And he's been,
I'm saying during the time he was supposed to show up for the PSI, he was in the hospital.
for the past 15 days, Judge, he's been in the ICU.
Okay, what day do we? Do you know, Ms. McRae?
Yeah, so it was originally set for March 12th, and he KPS on that date. And I will say that the re-referral says he absconded from parole on 12/23/2020, and they've tried twice to, it's been re-referred twice.
Okay.
Respectfully, Judge, he's been in contact with me. As to this case, he never KPS because he's been in contact with me concerning this case before. And last time he was on the record, and he did indicate that he was in a rehab, in an inpatient program. And the court did speak to him to verify that, Judge.
And what date was that?
I gotta check my.
I don't have anything about that in my notes.
That was the last, that was on March 12th, Judge.
Okay, so that's the day he took a plea, is that correct?
No, that was the day that he was re-referred for sentencing, Judge.
Okay, so he was supposed to go previous to that date. He didn't go. So we saw him back on March 12th and told him to go to call today, which must not have done, or did they give him a date? And then subsequently later, he ended up with COVID. So
Correct. He's in a serious condition, Judge, in the hospital.
Okay, the court needs some paperwork to that effect.
Well,
The court,
Judge, can we adjourn it to get verification? Can we get 30 days to find out
No,
once I get
it's gonna get
document?
30 days. It does not take 30 days to get paperwork about him being in the hospital. We need to have some paperwork by next week. Otherwise, I'm gonna KPS him because he's already had a history of not showing up. So
Can
you need to have paperwork to the court by next Friday.
Respectfully, Judge, can we do the 23rd if that's possible, 2 weeks, just to make sure that he's out and he's able to get the paperwork?
Well, his girlfriend can get the paperwork. Didn't you indicate you spoke with her?
Well, Judge, due to HIPAA, I don't think she'll be able to get any paperwork on his behalf.
Okay, 2 weeks.
Thank you, Judge.
Okay.
Judge, just to put on the record, on the PSI says on March 15th, he was at the Oakdale Recovery Center.
He called a case. I was just talking to him, but
Okay, never mind.
he live yet on YouTube?
Yes, we are now. We just got live.
Okay, now you can call the case that we just got through discussing
I
off.
don't even know the case name, number, anything. It's not on today's docket, so I
It's
would
not
like
on the
to-
docket. Do you know the case number? Counselor?
Madam Prosecutor, do you have I have the 36 number, I'm sorry, the county number. Do you have the case number?
Yes, it's 20-004805-01-FH.
Okay, what status is it right now? Is it on the capias? Or is it set for a different day for sentencing?
I
It's
didn't
10.
get anything under that number. Say the number again. 20 what?
Let me put it in the chat. 20-004805. And I just put it in the chat too.
Aaron Rittel.
Yes.
This is case number 204805, People of the State of Michigan versus Aaron Wertel. Scheduled sentencing today. Appearances for the record, please.
Good morning, Your Honor. Andrea McCray appearing on behalf of the people, P number 836.
Respectfully, Your Honor, Attorney Eloamle, bond number 6687 on behalf of Mr. Aaron Wartel.
Okay, off the record, there was some conversation with respect to Mr. Wartel. He's not on the docket today, but for some reason,
He is, Judge. I'm sorry, he is.
he is on the docket. Okay, on the
Yes.
one sent to me, his name is not listed. But, okay, he was there for sentencing. I guess my understanding is there is not a PSI because he did not show. And my understanding from defense counsel is he is in the hospital with COVID. And so the court, because he has, it appears, absconded from parole, and he was here on March 12th, in which he did not go, not PSI done, and we told him at that point, we re-referred him. Now it seems as if he's in the hospital. So the court doesn't know one way or the other, but the court is saying that some paperwork needs to be provided to the court before the court issues a habeas, and the court is going to give it to get that paperwork in. So we will just schedule it for 2 weeks from today. I understand quite a few matters in the day, but I just want to make sure I have the paperwork in that day. It won't actually be a sentence because it won't have had enough time to do the pre-sentence report. Okay? So it'll be
Thank
a
you, Your Honor.
review date in order for you to submit to the court the paperwork on this person. Madam Clerk, please put some kind of note there so I'll know what this is when we come back 2 weeks from now.
4/23 is the return date for your review date to submit paperwork.
Correct. Thank you.
Thank you, Your Honor. You have a wonderful day to you and your staff. Thank you, Judge.
All right, bye-bye. All right, now, let's go back to Willie Benjamin, which is Ms. Dawson and Ms. Burton. Let's call that.
Said Benjamin,
Yes.
this is case number 875921, defendant number 2, Willie Benjamin, scheduled review date. Appearances for the record, please.
Good morning, Your Honor. Lori Dawson, on behalf of the people, P40665.
Morning, Ms. Dawson.
Good morning, Judge.
Ms. Burton. Ms. Burton.
Yes, good morning, Your Honor. May it please the court, Delphia Burton appearing on behalf of Mr. Benjamin. He's in custody, Your Honor, at the jail, so he's not going to be appearing today. I asked to waive his presence for this review.
Any objection for the people?
No, Your Honor.
Okay, now I know this is a juvenile lifer hearing that needs to be. And Ms. Burton, I don't think we ever got the attachments to your brief.
Yeah.
You froze, Ms. Burton.
Judge, I may have to call back on my phone. For whatever reason, I'm freezing.
Okay,
Can you hear me now?
I can hear you.
You can hear me? Okay, go ahead. It's going in and out, but go ahead. You said Ms. Burton
I
something.
said we never got the attachments to your brief, I don't believe.
Judge, I resent them. Lori said it was only one page that came through, so I sent them to Hope Kennedy this morning. I didn't know there was only one page that went through. And that would have been a refile, Judge. Those were filed a long time ago. But I
I
did just
know,
resend
but
them.
yeah, but remember, the court didn't have them. The only thing we had here in the chambers was Ms. Dawson's huge binder. And then we had your brief, but we had no attachments. And while I'm reading your brief, I didn't have anything to reference because none of the attachments were here. I don't know what happened to them.
Okay, I did resend the Judge.
Okay, so they were sent today?
Yes.
Okay.
They were filed as well, refiled.
Okay, so the only thing is we are waiting for a hearing date to be scheduled by court administration. Is that correct?
I believe so, yes.
In person.
Yes,
Miss Kennedy.
correct.
Hope Kennedy, can you hear me?
Hope.
I just want to see
Here she comes, Judge.
Okay. I'm not sure, we might have been waiting on.
Yes, Judge.
Did we send a hearing readiness form for court administration for Willie Benjamin, or were we waiting on the the documents from Ms. Burton before we did that?
Willie Benjamin, we were waiting on documents to come over.
Okay.
So I just got them, so I can send everything now.
Okay, all right, so we'll send that out to court administration and we'll wait to get a date from them. I'll be honest and tell you, as much stuff as we sent to court administration saying we're ready, we literally only had one thing sent back with a date, and that was a sentencing, in-person sentencing that we did. We have not heard anything else. You know, they're coordinating every court, and now that the numbers have gone up, we're still doing in-persons though, but we just have to wait. I have no clue when it's.
Okay, well, thank you, Judge. We'll wait to hear from you then.
Okay.
Okay, thank you, Your Honor.
Thank you.
Thank
All right,
you.
bye-bye. Have a great day.
Bye-bye.
Bye-bye.
So we're giving a new dummy date for him.
Oh, yeah,
Judge, we need to have
Yeah.
a date.
I know, they're already signed off. Just set it for 2 months out.
Okay.
We can always call them.
Okay, I'm setting for June 4th. June
All right.
11th.
June 11th?
Yes.
Okay, that's fine. All right, let's move on. Anybody have an arraignment on the information or calendar conference?
Your Honor, Sally Irwin on Stephen Martin. We just need a date because we're in negotiations and I'm with Abigail McIntyre.
Okay.
Well, and Your Honor, I don't believe Mr. Irwin has also filed her response to the notice of intent to admit other acts.
Okay, well, let's call the case first.
This is case number 20698. People of the state of Michigan versus Stephen Martin, scheduled pre-trial. Appearances for the record, please.
Good morning, Your Honor. Abigail McIntyre appearing on behalf of the people, P71143.
Good morning, Ms. McIntyre.
Good morning, Your Honor.
Good morning, Your Honor. Sally Irwin on behalf of Stephen Martin.
Good morning, Ms.
Good morning, Your Honor. Steve Martin.
Good morning, Mr. Martin. How are you today?
Okay.
Okay. What was this set for today? A pre-trial or a calendar?
Your Honor, it was a special pretrial. I know Ms. Irwin, there has been an offer made by the people, and Ms. Irwin is attempting to resolve it. She and I have been in conversations regarding it, and she asked for an opportunity to present the people with some supporting materials to hope to change the offer. We have not received that as of yet. And also, I think the court directed her at the last hearing to file a reply for the statement of notice to admit other acts.
Okay, so
And that hasn't been filed yet either.
All right, Ms. Irwin, let me ask you this, Ms. McIntyre, was the last offer, the current offer put on when we were here the last time?
Yes, Your Honor, it hasn't changed because we haven't received anything from Ms. Irwin.
Ms. Irwin, what's going on? Why?
Judge, oh, excuse me. I just mailed verification of what I'm asking for to Miss McIntyre. It went out yesterday.
Oh, in the regular mail?
Yeah, the snail mail.
Okay.
So I'm really seeking to resolve this case short of trial.
Okay. All right. So you said you mailed it yesterday, correct?
Yes, I did.
So if that's the case, Ms. McIntyre should get it sometime next week. And then
Well, in Your Honor, and the people's position is right now the offer isn't changing, and I haven't had an opportunity to speak to any of my supervisors to know if there is a willing to change. I'm not sure there is, but to hear Ms. Irwin out.
Yes. Okay, so we're gonna give you time to receive that. Also, Ms. Irwin, are you planning on filing a response to the notice to admit other acts, evidence?
Yes, I will, Your Honor, based on whatever Miss McIntyre comes back with for me.
Well, I'm not sure one has anything to do with the other. I mean, she's already indicated whether they change the offer or not, you still probably should submit a response because she's indicated that's what she wants to use that trial. So you need to be prepared in case they don't change the offer. So you can still file a response to that.
You're kind of breaking up, but I think I got your gist that you want a response. So
yeah, I want a response in a week, Ms. Irwin.
Okay, yes, Your Honor.
Okay, so file your response unless you have no objection. You hear me, Ms. Irwin?
What was that, Judge? You're kind of breaking up on my end.
I'm sorry. This is technology, but I said unless you have no objection to her notice.
No, I will tender a response to this court.
Okay, all right. So the response is due next Friday. And Ms. McIntyre, I assume you should get this mail by next week and have an opportunity to speak to whoever you need to speak to. And
Well, Your Honor, Ms. Irwin, is there a way that you can just scan it and email it to me, and that way it would speed things up a little?
Yes, I can do that.
I would have thought that in the preferred way, anyway, Ms. Irwin. I'm not sure why you put it in the regular mail, but okay, you can scan it and then we can get a quicker answer. So 2 weeks. That'd be enough time. Well, I think we're looking at May anyway. By May 5th, we ought to be able to have this resolved, or either we're going to trial, right?
I agree.
May 5th's a good date for me.
All right, May 5th at 9 o'clock. And by this time, this should be resolved. Either we are going to resolve it or we're going to try to have a plea form on that day, or we'll be getting prepared to do a trial readiness.
And Your Honor, by May 5th, do we have to have witness lists and jury instructions filed?
That's what I was just getting ready. Make sure you file a witness list as well. The jury trial readiness form will have everything that needs to be done on there. So, we may have to meet again for that, but yes, file a witness list, and Ms. Irwin, get your response into the notice of other acts evidence. Okay.
Understood, Your Honor.
Okay. All right.
All right. Thank you.
Thank you.
All right. See you, Mr. Martin. Have a good day.
Thank you.
You're welcome.
You too. Thank you.
Bye-bye. All right. Any other quick matters? AOIs, calendar conferences.
Jeffrey Mack is an adjournment, if you'd like.
Okay. Jeffrey Mack.
Yes.
These are case numbers 21185, which is a final conference, and also 2893, which is a calendar conference. Both people of the state of Michigan versus Jeffrey Mack. Appearances for the record, please.
Good morning, Your Honor. Andrea McCray, appearing on behalf of the people, P number 83698. I'm standing in for both cases today. 185 is general trials. The other case is Pat 2, but I'm standing in for both.
Okay.
And good morning, Your Honor. From Neighborhood Defender Service, Jonathan Hortis, P78948, on behalf of Mr. Jeffrey Mack, who's on Zoom with us. Mr. Mack, can you state your name?
Yes, Jeffrey Demetrius Mack.
All right. Good morning, everyone. Good morning, Mr. Matt. All right. Why do we need an adjournment?
Judge, the people have made an offer on this case. That offer is staying open through April 29th. My client just needs a little bit more time to consider it. We're asking to come back sometime before that 29th expiration date.
Okay, Ms. McCray, did we put the offer on the record previously?
Oh, Your Honor, I'll put it on the record now. It would be on to plead to count 3 weapons carrying concealed. That carries a 5-year maximum imprisonment penalty, an agreement for a plea of guilty, and that's on case 21-000185, plea of guilty to count 3. People would dismiss counts 1 through 2 and 4 through 5. We would additionally withdraw the habitual third offense notice. There would be a sentence agreement. It would be 1.5 years to 5 years in the Michigan Department of Corrections. We would also dismiss Third Circuit case number 20-002893-01-FH, restitution on 20-002893 if applicable.
Okay, so let me make sure I have this correct. On the case ending in 185, Mr. Mack can plead to count 3, which is weapons carrying concealed. Remaining counts are being dismissed, and the habitual third is being withdrawn. There's a sentence agreement of 1.5 to 5 years. And then dismiss the other case, which is 283, and then restitution on case 185. Is that correct?
Yes.
Okay, Mr. Mack, are you aware of that offer?
Yes, he told me last night.
Okay. I understand you need time to think about that. So we will come back. However, I don't think we have any dockets to add it to by the 29th. I'm going to ask Ms. McCray, because the court just has way too many matters in the month of April. Ms. McCray, can that offer be left open until May the 5th? Next time you guys come back.
Yeah, Judge, you're coming in and out, but I think I said May the 5th, and I will keep the offer open until May the 5th.
Okay. All right. We'll see everybody back on May the 5th. On May the 5th, I should either have a plea form or we should be getting ready to do a trial readiness form. Okay.
Understood, Judge. On that date and time, I will have to send stand-in counsel. I'm beginning a leave on May 1st, but I will make sure that whoever comes in is prepared and knows everything about the case.
Okay, that's fine.
Thank you, Judge.
Thank you.
I also have one additional matter with you, but it's a plea on a misdemeanor and possibly moving for immediate sentencing on hour.
Okay. All right. All right, Mr. Mack, you're concluded.
Thank you, Judge. Have a good day. Hope you feel.
Thank you. Thank you. Okay.
For AOI on Keothis Miller.
Okay. Let's call that case.
This is case number 211744. People of the state of Michigan versus Keothis Miller, scheduled to be arraigned on information. Appearances for the record, please.
Good morning, Your Honor. Andrea McCray, appearing on behalf of the people, P number 83698.
And good morning, Your Honor. Katrina Wright, P 82097, on behalf of Mr. Keothis Miller, who is present via Zoom and consents to this proceeding being held via Zoom. Mr. Miller, can you please state your name?
Keothis Miller.
Okay, Ms. Miller, good morning to everyone. Madam Counselor, do you waive the formal reading and stand mute?
Yes, we do, Judge.
All right, the court will enter a not guilty plea as to your client. Madam Clerk, is there an information? You know, I don't have files. So is there information with the charges in the file?
Yes, there is an information.
Okay, is it signed?
It is signed, Judge.
Okay, and there are no amendments? It's the original information? You don't see an amended information, is that correct?
It's the original information.
Okay. All right.
The exam is held and the transcripts are due 5/3/21.
Okay.
Okay, transcripts are due 5/3. 21. So, on your sheet, and I'm gonna have to sign all these documents when I get back in and send them to the parties, but you will get typical discovery in your scheduling order. What day do you, let me ask this, defense counsel, do you anticipate filing any motions?
I do, Judge.
All right. What's the final conference date you have on the schedule, Madam Clerk?
Okay, your dates were, the motions were timestamped as 5/21, and the heard date is 5/28.
Okay, so we're gonna change that. I'm going to have them time stamped and filed by 5/28. Okay. And
That's
then
the date our motions are due, Judge, by May 28th.
that's correct. That'll be the date that they need to be time stamped and filed, May 28th. And then, I'm sorry, I didn't say that. It'll be May 21st. May 21st, that the motions will be time stamped and filed. The response, I give people get a response in hearing them in a week. So the response by whichever party needs to respond, depending on who filed the motion, the response will be due on May 28th. And then the final conference will be held a week from that day. Madam Clerk, what's the week from that day?
From 5/28, it is 6/4.
Okay, they will be heard on June the 4th.
Okay, I have an exam in 36 at 9:30 on that day, Judge.
Just one exam?
Yes.
Is this a lengthy exam or no?
It may be,
Let me ask you this. The most important question is, who is it in front of?
it's in front of Judge Giles, so it may not be.
Yeah, that probably won't be that lengthy. Okay. We'll leave it at June 4th. We'll set it for 11 o'clock.
Okay.
All right.
All right.
Is there an offer from the people in this case?
Not at this time, Your Honor.
Okay. All right. If you all speak and you can resolve the matter before June 4th, then contact the court and we'll put it on the docket.
Okay. Thank you, Judge.
Mr. Miller,
Yes, ma'am.
next time that I will see you on June 4th. Okay.
June 4th.
Yes.
Thank you, ma'am. Hope you feel better.
Have a great day. All right.
Thank you, you too. Okay, any more AOIs or calendar conference?
This is James Schloff. I have a motion to withdraw.
Really? Mr. Schloff, why, oh, why? Who is your defendant, Mr. Schloff?
Tyvon Claypool, Your Honor.
Is he on the call? Mr.
He
Claypool?
is.
And Your Honor, I'm the prosecutor on that matter. Good morning.
Good morning. How are you this morning?
I'm well, thank you.
Okay, let's call that real briefly.
This is case number 196312, defendant number 2, Tyvon Claypool, scheduled today for a pretrial and motion hearing. Appearances for the record, please.
Laura Nersessian on behalf of the people, Your Honor. Good morning.
Morning.
And good morning, Your Honor. For the record, James Schloff on behalf of Mr. Claypool.
Mr. Claypool, are you on the phone?
Yes, ma'am.
All right, Mr. Schloff, you want to withdraw for what reason?
Your Honor, I have been on this case for a long time, and I've appeared on Mr. Claypool's behalf in many different occasions. But in the last couple of weeks, I received a phone call from another attorney who wishes to offer a second opinion on the case. Now, I have no problems with another attorney coming in on the case, of course, and would always cooperate with that attorney. But for the purposes of shipping off my file for another attorney to offer an opinion on the matter, and then take no responsibility for his opinion afterwards, and leave a potential conflict there for my client, or anybody else, I should say, and his family, to say, well, the other attorney said you should do this or you should do that. That's not acceptable to me, Your Honor. I have no problems discussing matters with my client, educating him, offering him options, but I don't want another attorney offering his opinions without taking the responsibility.
Mr. Claypool, have you retained another attorney?
Yes, ma'am, I have retained another attorney. I do agree. I haven't been presented with things I believe I'm entitled to. I mean,
Okay.
such as a discovery.
Who is this attorney that you retained? Because whoever he has not filed an appearance on this case. Who is their attorney?
Markin L. Lincoln.
All right, he's not on this call today, Mr. Claypool. So at this point, I need to get an appearance before I can release Mr. Schloff. Did you do whatever it is you needed to do to make sure he's retained?
I'm still doing things to make sure he's retained. I mean, I have gave him a retainer fee. So I'm still working on it.
Okay,
But
well, Mr. Claypool, that means he's not retained because he has not filed an appearance on your case, and he's not here today. Did you tell him that you had a hearing today?
yes, ma'am, I have.
Okay, and he's not here. So at this point,
Understood.
he's not your attorney. So, I mean, I don't have a problem. This is a 2019 case, so we need to move it. How many attorneys have you had besides Mr. Slaw?
That's been my only one, ma'am.
Okay.
Correct.
All right. Well, if you're representing an attorney, the court has no problem with that, but I mean, you can't be not represented. So I hesitate to, I will eventually allow Mr. Slough to come off the case, but I need to know that you have an attorney. And right now I don't know that because he has not filed an appearance. So you need to get in touch with your attorney. If you like, you can mute your phone and try to contact your attorney now and see if he will appear on this call. And then I'll let Mr. Slough off the case. Do you want to do that?
Yes, ma'am. Give me a second.
Okay, mute your phones. We can't hear. Mr. Slough, just hold on a second, okay?
I will, Judge.
If we can get him on here. All right, let's move on to something else while we're waiting on that.
Good morning, Your Honor. I have Mr. Anthony Brock for a calendar conference. I
Okay.
think he was being read out from the Michigan Department of Corrections today.
That's supposed to be at 10 or 10:15.
Okay.
And
Somebody's in the box.
Are they in?
Who? The gentleman in the box. What's your name?
Darnell Wilson.
Are there parties on Wilson here?
That's also the co-defendant
That's the
on Mr. Brock's
co-defendant.
case, Judge. So that's Evan Callanan, and I believe he said he'd be back at 10:15.
okay, so it's Brock and Wilson.
Yes. ma'am.
Yes.
Now, let me say this to the parties. I know we have to wait on Callanan. Well, let's wait on Callanan. He's not back yet. All right. Anybody else have a calendar conference?
Judge, I have a sentencing for Deja Baker.
Your Honor,
Is there a way I can get her to call me though? Because I have the PSI, but I haven't been able to reach her to go over it with her.
Oh, then you're
I'm
not
trying to
ready.
get that done ahead of time, ahead of you calling the case.
Deja Baker, are you on the call?
Yes.
Okay, she's out. So, Mr. Kuja,
Yeah.
does she have a copy of it?
No, Judge, I've tried calling her and it says her phone number is disconnected, but if she has my number, so if she can call me somehow.
Yeah, I was having a problem this morning. I just connected it back. I'll call you.
Okay, you all mute your phones because you're out. And you can email it over to her and go over it, but you're not ready to do it right now.
Right. Thank you,
Okay.
Judge.
You're welcome. All right, anybody? Go ahead, Mr. Snyder.
Thank you, Your Honor. I'm walking my client in Tyrone Douglas on an open probation violation warrant. I know it's not a calendar conference or AOI, but I do think it would be fairly quick.
Okay. What's your client's name?
Tyrone Douglas. He's present on the call.
All right. Ms. Schoen, do you have any information on Tyrone Douglas?
Yes, I do, Judge.
We're tracking a new case out of the 36th District Court. Well, actually, it was just bound over yesterday.
Okay, that'll be pretty quick. Okay, what's the case number?
18,
185543. People of the state of Michigan versus Tyrone Douglas, scheduled to be arraigned on violation of probation. Appearances for the record.
good morning, Lori Schoen, Department of Corrections.
Good morning, Your Honor. NDS Detroit. Henry Schneider, P82476.
Okay, you're kind of going in and out, but I see you. Where's Mr. Douglas?
Present.
State your name for the record, Mr. Douglas.
Tyrone Douglas.
All right, this is a probation violation.
Yes.
Has they been on the warrant?
That's what we're doing today.
Okay, all right, your client, not guilty and stand mute?
Yes, please, Your Honor.
All right, court will enter not guilty. What's the issue? Is this because he picked up a new case?
Yes, Judge.
All right, are we just tracking this?
Yes, please.
All right, so when was he bound over on the other case?
Yesterday.
All right, so we need probably about 3 weeks.
Yes, please.
Was this Out County or 36th District?
36th.
Okay. Madam Clerk, what's the next date?
7. May 5th or May 7th.
May.
Could we do May the 7th, please?
That's fine. May the 7th at 9 o'clock. Mr. Douglas, we'll see you back on May the 7th at 9 o'clock, okay?
Yes.
Mr. Snyder, can you please send me his address and phone number
Yes.
for probation?
Put that in
Thank
the
you.
chat, Snyder.
And Your Honor, could you place myself and Mr. Brock in a breakout room? He's in IBC segregation.
Well, let me tell you this. Court, because the court is sick right now.
I'm
is
sorry, Your Honor.
Not in the court. The court is at home and on a laptop. So I can tell you this. I will try to place you in. Normally I said at the beginning of this call, I wasn't doing any breakout rooms because the technology has just been crazy today. But I understand that your client is in custody. So I will try to do it. I'm not sure what's going to happen. We'll see. And if it works, hopefully it will work. If you get disconnected, you just have to come back. So that's Mr. Brock is your client?
He is, Your Honor. He's in IBC segregation.
Okay.
Your Honor, for the court's awareness, Mr. Callanan is in the waiting room. He just texted me on Mr. Wilson.
Okay. We'll admit everybody that's in the waiting room. And let me do a breakout room with Mr. IBC segregation. Let's see. All right, Mr. Toussaint. Okay. All right, you should get an invitation in a minute to go into a breakout room. I just hit open the room.
Thank you, Your Honor. I have it.
Okay. Mr. Hart has been waiting. Mr. Hart, what are you here for?
I have my last remaining case is Robert Auer. It's a plea to a misdemeanor, and we were going to ask for immediate sentencing if you're inclined. There is a sentence agreement on it.
Okay. Do we have the plea form?
It was sent to your clerk.
Who is the client?
Robert Auer.
What's the last name you saying?
Auer, A-U-E-R.
Oh, okay, thank you. These are case numbers 203510 204413. Both scheduled final conferences, both people of the state of Michigan versus Robert Howard. Appearances for the record, please.
Good morning, Your Honor. Andrea McCray appearing on behalf of the people, P number 83698, appearing on both cases.
And good morning, Your Honor, from Neighborhood Defender Service, Jonathan Hortis, P78948, on behalf of Mr. Robert Auer, who's joining us on Zoom. Mr. Auer, can you please state your name?
Robert Auer.
All right, good morning, Mr. Auer. Now, here's the issue we have. Somebody's got to send me a plea form.
It's coming now, Judge.
Okay.
And Judge, if you'd like, I could share my screen to display it if you needed to.
That
If,
would
uh,
be fine.
Let me pull that up. Can the court see that?
Yes.
Okay, I'll zoom out so that it's legible. Let me know what you want me to do with it if you want me to move it.
That's fine. I can see it. I just can't see the signatures on the bottom. Okay, I see it now. Can you make it a little smaller and then that way I can see the whole thing? There we go. Okay. It appears as if. All right, so.
Client is requesting, defense is requesting immediate sentencing too.
And the people are.
Okay, let me pull up my, so I can get my information. Hold on one second. It's on my email as well. Okay, all right. The parties have reached a plea agreement and prosecutor, please state the terms for the record.
Yes, Judge. So there are two cases. I'm referring right now to case 20-003510. So the plea agreement would be a plea to a reduced count 1 of controlled substance use of heroin. That's a 1-year misdemeanor. It would be a plea of guilty as charged to count 2, operating while intoxicated. That is a 93-day maximum misdemeanor. The sentence agreement would be 2 years probation. The people would agree to dismiss Third Circuit case number 20-004413-01-FH. Defendant must undergo substance abuse evaluation and treatment if recommended. Random drug screens in the first year of probation. No objection to immediate sentencing at time of plea.
That's
Okay.
our understanding of the agreement, Judge.
Okay, and Mr. Auer, is that your understanding of the agreement as well?
Yes, Your Honor, it is.
All right, Mr. Auer, I want you to raise your right hand, please. Do you swear or affirm that the testimony you're about to give is the truth?
Yes,
Mr. Auer, how old are you?
32 years old.
And how far did you go in school?
I'm close to graduating college.
Okay, very good. What college?
I went to Purdue originally, but I'm going to finish at University of Michigan, Dearborn.
Okay, very good. All right. And I take it then you read and write the English language.
Yes,
You understand what's happening here today?
I do.
And you consent to take a plea over Zoom?
Yes.
I'm looking at a form that's entitled Settlement Offer, Advice of Rights, Notice of Acceptance. It says that the prosecution is allowing you to plead to count 1, which is a reduced charge of controlled substance use, heroin, which is a 1-year max, and operating while intoxicated, which is 93 days. On the agreement, there's a sentence agreement of 2 years probation. The people will dismiss the Third Circuit Court case number 20-00441301. Defendant must undergo substance abuse evaluation and treatment if recommended. Random drug screens in the first year probation. No objection to immediate sentencing at the time of the plea. There's a signature at the bottom, which is your attorney's signature, and then there's your name. Did you give your attorney permission to sign your name or put your name down?
I did, Your Honor.
All right. Do you understand that by taking a plea here today, you give up certain rights? Did you go over these rights with your attorney on this form?
Yes, I did.
All right. If the court accepts your plea today, you'll be giving up the right to be tried by a jury or to be presumed innocent until proven guilty, or to have the prosecutor prove beyond reasonable doubt the charge. Can you hear me?
You were going out at the end, but I know that I'm giving up the, I know, I agree.
Mr. Slav, can you put your phone on mute? Okay, there's some more background noise, but that might be the facilities. Okay, I still have to go. Okay, let me say that again. You're giving up the right to be tried by a jury, to be presumed innocent until proven guilty, and to have the prosecutor prove beyond a reasonable doubt that you are guilty. You understand those rights?
Yes.
You have the right to have witnesses against you, giving up the right to have witnesses against you appear in court and to question those witnesses against you, and to have the court order any witnesses that you have to appear on your behalf. You understand you're giving up those rights?
Yes.
You're giving up the right to remain silent during the trial, to not have that silence used against you, and to testify at trial. You so told. You understand you're giving up that right as well?
Yes.
Okay. And if your plea is accepted, you'll be given up the right to claim that the plea was the result of promises or threats that were not disclosed to this court during this proceeding. And you're giving up that right?
Yes.
If your plea is accepted, you may be given up the right to appeal issues that would otherwise have been appealable if you were convicted at a trial. And any appeal of your conviction or sentence would be by application of leave and not by right. So what that means is, by you taking a plea, if you later have some issues with respect to your plea and sentence, you would have to ask the Michigan Court of Appeals to look at that. If you had been convicted at trial, it would be automatic. So if you take this plea, you will understand that you're giving up the right to have the Michigan Court of Appeals look at your situation automatically. You understand that?
Yes, I do.
All right. After going over all these rights, is still your wish to plead guilty today?
Yes.
All right, Madam Prosecutor.
Yes, thank you, Judge. Mr. Robert Alexander, is it Hour?
Yes, ma'am.
Hour, okay. I want to take you back to the date of April 13th, 2020, okay? On that date, did you find yourself at the place of Ford and Haggerty Road, Haggerty?
Yes.
Okay, and is that location in the city of Canton Township, County of Wayne, State of Michigan?
Yes.
Okay, and on that date, at that location, did you use a controlled substance, that being heroin?
Yes.
Okay, and had you didn't obtain, there was no prescription for that heroin, right?
No, ma'am.
Okay, and you had no legal right to have this heroin and use it, correct?
I did not have legal right now.
Okay, and you knew it was heroin?
Yes, ma'am.
Okay, and also on that date and on that time,
I'll try. I've been there twice now and waiting for.
Who is that that's speaking in the background?
Mr. Callahan or Callanan, can you mute your microphone?
Okay, go ahead.
Okay, Mr. Auer, so on that date of April 13, 2020, did you also drive a vehicle?
Yes, ma'am.
Okay, and when you were driving or operating that vehicle, did you do so on a highway, that being Ford Road?
Yes, ma'am.
Okay, and were you driving that vehicle on Ford Road while you were under the influence of controlled substances?
Yes, ma'am.
Okay, and were those controlled substances cocaine, fentanyl, and morphine?
I don't recall. I'd never heard about cocaine. I never used cocaine, but fentanyl and morphine would make sense.
Okay. So to be clear, you were driving your vehicle while under the influence of fentanyl and morphine, correct?
Correct. Yes.
And did that affect your ability to drive?
Yes, ma'am.
Okay. Judge, well, before I say I'm satisfied, I would move to amend the information to take out cocaine of count 2.
No objection.
Okay, take it out.
And with that, I'm satisfied, Your Honor.
And to satisfied.
All right, has the court complied with the court rules, 6.302?
Yes, Your Honor.
All right, court finds that the defendant's plea is understanding, voluntary, and accurate, and will accept the plea of guilty. The defendant will be referred to probation, and that number is?
Oh, Judge, do you not want to do an immediate sentencing on this one?
Right, we are doing immediate sentence. Okay. Anything you'd like to say on behalf of your client?
Yes, Judge. This is represents a bit of an aberration for Mr. Auer. I've had an opportunity to speak and work with him extensively on this case. I know that he is currently successfully self-employed. I know while he is pursuing college, as he stated earlier, he does have this business that has been doing well historically. Ultimately, I know that he wants to basically put this behind him, and I think that the favorable resolution in this case sort of reflects the good equities in his favor. I'm asking the court to follow the sentence agreement in this matter and to consider reducing court costs since we did resolve these matters short of trial.
Okay. Ms. McCray?
I have nothing to add, Your Honor.
Are you dismissing any?
Oh, yes. Okay, I will. At this time, the people would move to dismiss case number 20-004413.
No objection.
All right, they'll be dismissed. Mr. Auer, anything you'd like to say before the court imposes a sentence?
No, Your Honor.
Okay. The court will follow the sentence agreement of 2 years probation. The people have already dismissed the circuit court case of 200004413. Defendant must undergo substance abuse evaluation and treatment if recommended. Random drug screens in the first year of probation, and no objection to, I'm sorry, we have that part. Madam Clerk, what are the court costs for the misdemeanor?
75 and 53.
$75 state court costs?
Yes.
And 53 is for what?
The state minimum is 53 and 75 is crime victim.
Okay. So 53 is the state court cost and the 75 is the crime victims, right? And is it 1,300 court cost still or 1,300?
It is.
I believe for a misdemeanor, though, it can be 650, isn't it?
Judge's discretion.
All right. Court will set it at 650. And attorney fees are still 400.
Yes.
Court will waive the attorney fees.
Thank you, Judge.
All right. He still has to contact probation, however. What's the number, Madam Clerk?
I'm sorry, 567 5600. Does anybody know the number, Ms. McCray?
I believe it's 313-456-4600, if I'm remembering correctly.
That is the number. Okay.
I'm gonna text that to my client. I'm gonna text it to you, Mr. Auer.
Okay.
All right, you need to contact that office today, Mr. Auer.
Okay.
Good luck to you, Mr. Auer.
Okay, thank you so much.
Thank you. This matter is concluded.
Thank you, Judge.
Thank you.
Okay.
Your Honor, this is,
Back to Mr. Hart.
thanks, Judge. We've got Justin Hooker. It's up for sentencing.
Okay. All righty. I think I have his sentencing on email. I think they scanned it to me. So I just need to find it.
What are we doing now?
Mr. Hooker.
And Judge, just so you'll know, we submitted a sentencing memorandum wherein we were requesting the release of part of the sentence.
Oh, well, you know, Mr. Hart, we may, because I don't think I have the sentencing memorandum. I have not been in the office since Tuesday. Did not know I was gonna end up sick. So I don't have the sentencing memorandum in front of me. What
Well,
is?
how dare you get sick and be a human being, Judge? What's wrong with you?
I know. And I did bring some things home because I thought maybe I'd be out of day, but they won't let me back in the building, unfortunately.
The only real, the substance of the sentencing agreement is just a little bit of background about my client, which most of which is already reflected in the PSI. All I'm really asking for, this was a plea pursuant to a sentence agreement. We were
Right.
just asking that he get work release as part of the sentence. That's all.
Well, I can tell you this, because of COVID, they're not doing work release because they don't want people coming in and out of the jail.
What we did as part of the plea, Judge, there is a slight change to the PSI. The original deal was for probation with the first 6 months in the Wayne County Jail. And we amended that at the time of the taking of the plea to, it doesn't have to be the first 6 months that he serves his time, so that if a year down the line, they're doing work release, he can do his work release.
So we're putting it at the end.
At some point during the course of his probationary period.
Ms. McCray?
So I don't recall that. I thought that there at the last hearing, we had a question about whether or not we could do that. And I had to get permission from docket attorney because this was pursuant to a gun board letter. And I thought that I exchanged emails with Mr. Hart where Mr. Cobb had said no.
Yeah, that's all accurate. And then I checked with, actually, this is Sarah DeYoung's case. And she said, yeah, that was fine.
So, okay, so I wasn't a part of that conversation with Ms. DeYoung, but Bradley Cobb is the supervisor and docket attorney for Judge Baker. So I don't know anything about that.
Okay, so it looks like we have an issue, which is something I can't resolve today. So it looks like we're gonna have to adjourn this because I can't, if it's a sentence agreement, the people have to agree. Secondly, I'm not sure you can do 5 years probation anymore. There have been new criminal justice changes that I believe have taken effect now. And I think that the most you can do is a 3-year probation on a felony. So that is another issue, but I don't have that paperwork in front of me either. I don't think you could do 5 years any longer. So I think we're gonna have to condemn it. We are, because there's no consensus between the people and the defense. Yes, I will give you May, what is it, May 5th?
Or 7th.
May 5th or 7th, which one?
5. May 5th?
Yep, May 5th is fine at 9 o'clock. And Ms. Schoen just sent me something in chat and she is right. 3 years probation is the max that you can do on a felony now.
Does that apply moving forward, or like if cases were, you know what I'm saying? If cases were already entered into a plea, does that apply to those?
What
Research.
That I don't know.
It would seem to me if there's a statutory change, if the plea took place, I mean, if the sentence is taking place after the change comes into effect, you can't sentence to longer than what?
It's always based on the date of the plea.
Yeah. What day did he take a plea?
January 29, 2021. I'll do the research on it, Judge. And Mr. Hart, if you could forward the emails to me and Mr. Cobb with you and Ms. DeYoung, that would be great.
It wasn't a email. I got the one you sent me saying that Brad rejected it or whatever. So I called to talk to Brad about it. They hooked me up to Sarah. Sarah said she was surprised that it went to Brad to begin with because this was her case, and she said it was fine. We could do the
okay. Well,
during the
we can't do that right now because the court has to move on. We got a lot of people waiting. So at this point, you guys can figure that out. We'll be back on May the 5th, and by that time, everything should be figured out. Ms. McCray, you can do the research on whether it's retroactive or not, but I think, I'm not sure. The plea was taken in January, which is before the changes went into effect. However, I don't know how that affects it. So we'll see. Okay. But we'll be back on May the 5th at 9 o'clock.
Very good. Thanks, Judge. Feel better.
Thank you. You too. Have a good day.
Thanks.
All right.
I went over that PSI with Deja Baker and her co-defendant. I'm going to stand in for her lawyer, Chris Kessel, whenever you're ready for us, Slayton and Baker.
All right, let's go back to Claiborne and Mr. Schlaf. Is Mr. Claiborne still on the line?
Claypool.
Claypool, I'm sorry. Mr. Claypool. Oh, wait a minute, he's in the waiting room. That's what I'm gonna find out now. Mr. Claypool? You're muted, Mr. Claypool. You have to unmute your device. Okay, go ahead.
Here you go. He said he'll be signing on in 10 minutes.
Okay, well then that being the case, Mr. Slough, I will release you from the case. If for any reason he does not sign on, I guess we'll be calling you back.
Okay.
You muted Mr. Slough, but I assume you said okay. All right. Okay, now we have a situation with Brock and Wilson. Is Mr. Tucson out of the room? Or are they still in the breakout room? I think they're still in the breakout room. So then Mr. Claypool, you could just hold tight until you get someone.
I'm sorry, he's not my attorney. He said that he was going to come on to speak and let you know what's going on here. I guess to say it better than I can.
Well, if he's not your attorney, he's not coming on to speak on your behalf. He has to be your attorney.
Okay. Well, I will let him know that.
Yes. Otherwise, Mr. Slough will call back.
Okay. Is it possible I can get another court-appointed attorney? I'm not able to afford a lawyer right now.
Okay. Okay.
I
Yes.
haven't been.
Okay, Mr. Claypool. We will, Madam Clerk, I think we have to contact. Who do we have to contact in order to get an assignment for Mr. Claypool?
Hope will contact court administration. Clerk can't do it, but she's doing it now. She's doing it as we're speaking.
Okay, Mr.
We'll
Claypool.
know. Just hang on, Mr. Claypool.
Mr. Claypool, mute your phone and we'll see if we can get you an attorney, okay?
Yes, ma'am.
All right. Now, before we go to anything else, any more calendar conferences or AOIs?
All right. I believe we're up for calendar conference. No, we're up for pretrial. I'm sorry.
Well, pretrial, who is your client, Mr. Bicker?
Mr. Sparkman. This is going to be short.
Okay.
Mr. Sparkman, we just received an offer. I just need some time to go over it with Mr. Sparkman and see if it's going to change or not.
So there is no offer.
Correct. That's
Okay.
Fair enough. That's accurate. That's what was conveyed to me. That's correct.
You can call Mrs. Sparkman.
This is case number 204924. People of the state of Michigan versus Brian Sparkman. Scheduled calendar conference. Appearances for the record.
Good morning, Your Honor. Andrea McCray appearing on behalf of the people, number 83698.
May I please court Your Honor, Tyrone Baker, appearing on behalf of Mr. Brian Sparkman, P number 62647. Mr. Sparkman is present via Zoom.
Mrs. Sparkman, state your name for the record.
Hello, my name is Brian Sparkman.
All right. Good morning, Mr. Sparkman.
Good morning.
This is a pre-trial. Were we trying to work out some type of resolution?
No, it's not, Judge. It's a calendar conference.
Oh, it's a calendar conference. Sorry. All right. Is there an offer from the people?
No, Judge. So this is a one count of CCW. He's HIDA eligible at 20 years old, so there would be no offer from our office.
Okay.
Your Honor, if the court were so inclined, I just full disclosure, Mr. Sparkman is on HIDA probation. The facts of this case there are some kind of facts that I was going to present on his behalf that I was hoping that we could reach a resolution short of a felony for Mr. Sparkman. But if the court were inclined to consider HIDA for Mr. Sparkman, I think that he will be prepared to move forward today. But if not, I would like some additional time to see if I can do anything with the prosecutor's office. The facts of the case are somewhat.
Hold on a second. What is he on HIDA for now?
I believe for CCW, Your Honor.
And this is another CCW?
That's correct, Your Honor. However, like I said, and I don't have any problem with.
I think under the HIDA, I don't think he can get Once you are under HIDA, under CCW, there are certain crimes that prevent you from getting another HIDA. And I believe CCW is one of them, but I do not have the book in front of me. So that being the case,
I would have to read. I'm sorry.
yep, you need to look under the HIDA statute, madam, and we don't have time to do all of that today. And as I indicated, I know Mr. Bicker, you came on later, but the court or the judge is sick, so she was not allowed in the building. So I am doing things by remote from home. So I don't have my normal books and all that kind of stuff.
Understood.
But by memory, I believe if you are on HIDA, there is a list of certain crimes that if you pick up while you're on HIDA, then the previous HIDA has to actually be revoked and you can't get another one. And I think CCW is one of them, but I don't have it in front of me. So what we're going to have to do is pass this matter. Know that the prosecutor's office is not going to give him anything else because they're saying he's HIDA eligible. He already has a HIDA. I mean, Madam Prosecutor, I think there's an issue there. You all are looking at it as he's HIDA eligible, so we're not going to do anything, but I don't think he can get it because he's already on HIDA for CCW. But that can be looked up. It's not the court's job to do that. So we are going to set this for another day for right now.
Want to give him his final conference dates, or are you changing this date? Because this is the calendar conference.
What's the final conference date?
5/28, and if they reach something, they can always call me.
That's fine. 5/28, final conference. Hopefully we get it resolved before the end. If not, by 5/28, something will be done. Either we'll be going to trial or he'll be taking a plea. Okay?
Understood, Your Honor. I will look into it and obviously follow up with Ms. McCray about, you know, what the options are or not.
Right, because if it's an issue where your client, you know, is going to be revoked automatically, he can't get it, then maybe they can come up with something else. Okay.
Right, and understood, Your Honor.
Okay. All right. Mr. What is that? Sparkman?
Yep.
Mr. Sparkman, okay, your attorney will talk with the people and hopefully you all can work out something. Have a good day, Mr. Sparkman.
You as well.
All right.
All right, thank you, Your Honor. I'll be in touch, Mr. McCray.
All right, are we, is Mr. Toussaint back? Not back yet. I see his client. See what's going on. Hold on. All right, I just.
Yes.
All right, we got a lot of background noise in the back. Is that just at the facilities?
Tell me the who.
All right, are we ready on, is it Brock?
I'm ready, Judge. I think Mr.
Callahan,
Yes, I'm ready, Judge.
defendants are here?
Yes, Your Honor.
Okay, you can go ahead and call the case, Madam.
I don't think Mr. Toussaint is on, Judge.
Mr. Toussaint, I see his name.
I see his name. I've just texted him and told him that you're ready for us, Judge.
Jeez.
Mr. Toussaint?
All right, maybe he's in another court.
Oh, he just chatted and said, can we please pass?
Okay, that's fine.
Your Honor, can we please pass this? Oh, shit.
That's fine, Mr.
We can hear you, Vince.
I'm sorry. Can we please pass this matter? I'm on a plea proceeding in Livingston County. I can't
That's
do
fine. That's fine. Just mute your phone.
I will. Thanks.
Okay. All right.
Well, he said you gotta be faithful, brother.
Has the phone Angie B?
He's the head.
Who has the phone, Angie B?
No, but you don't understand. This man got an empire.
Hello?
He's the CEO of the whole family. He's the head honcho. Oh, in White Lake, just above Pontiac, like next to Pontiac. He live on a lake. He built
Tell,
it himself.
Madam Clerk, tell Hope to go to my chambers and to mute that phone. Not let me do it for here. And I don't see it.
doing it. She's attempting to do it now.
I think we ended up getting rid of it. All right, let's move on. All right, who else do we have next that's ready?
Judge, this is Sinclair. I'm here on a motion hearing for a motion to quash. I don't know if the court is ready to hear that yet, but I'm here and ready. And Mr.
Who is it?
Is this on Wilkerson?
Yes, ma'am.
Now the court is ready.
Okay.
This is case number 203989. People of the state of Michigan versus Eric Wilkerson, scheduled final conference. Appearances for the record, please.
Good morning, Your Honor. Andrea McCray appearing on behalf of the people, P number 83698.
Good morning, Judge. I'm Christopher Sinclair, appearing with it on behalf of Mr. Wilkerson. My P number is 80512. Mr. Wilkerson is here on the call, and we consent to proceeding via Zoom.
Mr. Wilkerson? You're muted. You have to take your phone off mute, Mr. Wilkerson.
Can you hear me, Your Honor?
Yes, I can now.
Okay. Okay, good morning.
All right, state your name for the record, Mr. Wilkerson.
Eric Wilkerson.
Okay. All right, so the court received defendant's motion to quash. The court has had an opportunity to review the preliminary exam transcript. The standard with respect to whether the reviewing court will grant the defendant's motion is whether it determines that the district court abused discretion in binding over the matter. The argument from defense is that he felt the judge was biased against the defense. And then there was also an argument with respect to malicious destruction of property. He felt that the element of the amount, which I believe is 1,000 or more, but less than 20,000. Malicious destruction of property, I don't have the information in front of me, but I'm assuming that's count. Is that correct?
I'm sorry, your audio cut out for a second. You said you're assuming what now?
Malicious destruction of property is count one.
Oh, let me pull up the information.
Because I don't have the information in front of me.
Okay. Let's see. I pulled up the motion, but I didn't pull up the information.
That's the count you have listed first. So I'm assuming that
Count one is malicious destruction of property, more than 1,000, less than 20,000.
All right, count two is carrying a concealed weapon. Count three is felony firearm, and count four is reckless use of a firearm. Is that correct?
Yes, ma'am.
Okay. So in the motion to quash, the defense has argued that they felt that the judge was biased. And the other argument was that the elements were not there for count one. Well, I'll deal with that, but I believe there was an argument made that the judge assisted the prosecutor, and without the judge's assistance, the value of the vehicle would never have been on the record. And then I believe the defense also argued that they don't believe the elements were met with respect to carrying a concealed weapon. So I will say that I did read the transcript. The issue of whether the judge questioning the victim in the case, whether that showed bias. Clearly, a judge is able to ask questions if they are confused about an issue. I will say myself that I don't know if the prosecutor was new or nervous or what, but she did not do a good job of being able to get the evidence in with respect to a couple things. One, as to the victim, when the victim saw her car was damaged. So I was confused myself. So when the court asked, I believe the witness's name is Pamela Tessera, asked Ms. Tessera about where she was when she heard the noise. She heard a noise, she didn't know what it was. It kind of was left there, and the prosecutor didn't indicate on the record how the victim even knew her car was damaged. And so I could see why the court would ask her questions as to how she found out her vehicle was damaged, because it didn't come out until the court asked her how she found out. She said the officer knocked on the door, and 5 minutes later she went outside and saw the bullet holes in the car, the holes in the vehicle. Now, I will say I do think the judge went a little far in asking the question, but with respect to destruction of property.
Judge, you're coming in and out.
Okay, can you hear me now?
Yes.
I don't know. With respect to malicious destruction of personal property, even if I struck the questions that the judge asked to get to the value, because the prosecutor was clearly ineffective in trying to get to the value of the vehicle, the defense asked the question again himself on, I think it was page 47. The defense then says, how much money were you paid by the insurance company for the vehicle? And the answer is 6,350. So the defense basically allowed the value to come back in. So that being the case, you
Judge,
know.
can I interject here, Judge?
No.
I'm sorry to interrupt.
No.
But I need to correct the record as it relates to what happened at the preliminary examination.
No, because the judge is talking. You cannot interject. The judge is speaking. So on page 47, when after the judge goes through a litany of questions to try to figure out what the value of the vehicle is, I will admit that the defense is correct. I think that it was a lot of questions with respect to the judge, and it should have been left to the prosecutor. However, as I just said, when the defense got up to recross on page 47, the defense then asked the question to the victim, how much money were you paid for your car being totaled out, basically in those terms? And the amount was still put on the record. So the elements are still there for malicious destruction of property. So I don't find that the judge's questions, you know, even if I strike the questions that the judge made, the elements are still met because the value was still put on the record by the defense's own question in the recross. So I don't find that there was an abuse of discretion in binding over malicious destruction of personal property. With respect to carrying concealed weapon, I do find that that was an abuse of discretion. There was no testimony that the defendant got out of the car, that any witness saw the defendant get out of this vehicle with a gun and shot up the victim's car. There was testimony by officer, his name is DeBono, that when he arrived, he did talk to witnesses who I'm assuming were the neighbors, that's what he said, who said that they heard gunshots and then a car speeding off. And then he did see skid marks. Now, we could make an inference that the defendant came in that car, shot from that car, and then sped off in the car. But I do think that's a stretch because for all we know, the defendant could have walked up and shot up the car. It could have been somebody else who was parked there who skidded off because they heard gunshots. We don't know how the defendant got there. And we don't know if he left in that vehicle, if he ran off. And maybe whoever was in the car just sped off because somebody was shooting in the area. So I think it was a stretch to bind over as to carrying concealed weapon because no one testified that they saw this defendant get in the car with the gun after they heard the shots. It would have been different if they had said, well, we saw African-American male get in the vehicle after we heard shots and then the vehicle sped off. But we don't have that because no one actually ever saw the defendant do anything for the victim or the witnesses that were there. So the court will quash the count of carrying a concealed weapon because I do not believe that there was evidence on the record to bind that count over. With respect to felony firearm and reckless use of a firearm, I believe that the elements were there and I think it should have been bound over because we do have the elements from malicious destruction of property, and that's the felony firearm, and that's the underlying felony for the felony firearm. The defendant himself admitted to the police that he was the one that did the shooting. He even told them where the weapon was. where the ammunition was and even told them what it was in. And they got a search warrant. They went and they found the gun exactly where he said it was. And then there was a Michigan State Police lab report. Casings were retrieved from the location, and those casings matched the gun that the defendant told the police where to find, and those casings came from that gun. So clearly, you have the malicious destruction of property. You also have more than 1,000, less than 20,000. You have the felony firearm and reckless use of firearm. So that is my decision with respect to the motion to quash.
Judge, I have a follow-up question on the court's decision. So just so I know how to proceed from here, and I apologize for interjecting earlier. I do know that the court has the discretion to dispense with oral argument. So again, I do apologize for interrupting the court earlier. So is it the court's ruling that the judge is able to violate the boundaries of MRE 6.14? And then when I asked, because if you read, of course, the court has read through the transcript. I couldn't hear everything that was going on. The witness was right next to the judge, and they were having this almost personal conversation. And I asked what he said. I couldn't hear what she was saying. I was objecting. The judge was ignoring my objections. He was doing like this, waving me off for my objections. So is the court saying the fact that I said, what was that answer? What did you say? Is the court saying that in a sense cures the judge's violation of 6.14?
I'm not saying that the judge violated 6.14. I agree that the judge asked probably more questions than I would have done, but I'm not saying that the judge was fired. I can't tell from the transcript that the judge was fired. But I think the judge was doing.
I can't hear you.
Shit, my baby in that motherfucker, man.
No.
Somebody has their, anybody who's not on this call, please mute your phone if you're not on this case until we call your case. If you're in a facility, please mute that phone. Mr. Wilson, mute your phone. Can you mute your phone in the facilities?
Oh, I can't touch. I'm in a cage. I can't touch it.
Oh, okay. All right. Is there anybody around you? I don't think there's any noise on yours, so I don't think that's coming from you. Mr. Wilkerson, you can mute your phone unless you can mute your phone.
Okay.
So I am not indicating that the judge violated the rule that you have cited because he was biased, and thus the cure for that is your question. I am not ruling that he was biased because I can't tell from the four corners of the transcript that he was biased. What I can say is that it appeared to me that he was asking questions to clarify the testimony because it was not brought out very clearly. And the judge has a right to ask questions to clarify the testimony. I think he asked more probably than I would have asked, but he has a right to ask questions to clarify the testimony. And there was a lot of issues that were left unclear, and he has to make a decision whether the evidence is there to bind over on the counts. And a lot of things were left that should not have been left. So the judge has a right to ask questions if the judge is unclear about what is being said. So that is what I'm saying to you. I said that with respect to the amount of the vehicle, I do think he asked more questions than he needed to. I think once the amount was established, and I think he asked a couple other questions about what time she woke up or something that to me really didn't have anything to do with the amount of the vehicle. But what I said to you is, again, the defense in their cross asked her again what was the amount of the vehicle, and so the amount is still on the record.
So are you
just that the elements aren't met for malicious destruction of personal property with 1,000 more or less than 20,000, because it's clear that the amount that she was paid for the insurance company was $6,000, I think $500 or $350 or $530.
So again, just for my clarity, are you saying without my question saying, hey, I didn't hear what you said, are you saying that the court was fully within its right to ask the questions that it asked as related to like the dollar amount of the vehicle and what she was paid from the insurance company and to go through all of the other testimony that the court went through?
I think the court was in its rights to ask questions about the value, yes, because that's an element of the crime, and that's what the court needed to know. Does she know how much she was paid? If she said she didn't know, and he bound it over anyway, then yes, it would be an abuse of discretion. But he's got to get the information. Just because the prosecutor doesn't ask it, the judge has a right to ask that question. He knows what he needs to look for. He can ask the question. So
And so
I don't find it.
there was case laws.
There's nothing in the transcript to me that indicates the judge was biased. I don't know about the judge waving their hand or whatever. I don't see that. I can only go by the four corners of the document. It's a motion to quash. I wasn't there. I can only go by what's written in black and white. And I believe that the court was asking questions in order to determine whether the elements are there. Him asking the question doesn't mean that there would have been an answer. If the victim didn't know, then the victim didn't know. And then you would not have had the elements. But he can ask the question. If the prosecutor doesn't ask the question, he can ask the question.
And one last question, Judge, as far as that is concerned. In my motion, I included case law that the court is not able to step into the shoes of the prosecutor. And so in my view, in order for the judge to be neutral and detached when they make their decisions, if the prosecutor doesn't prove the elements, then it's really outside of the scope of the judge's position, and his job as being neutral and detached to go ahead and fill in the gaps and go ahead and ask the questions and do the prosecutor's job to prove the case. So is the court finding that that this judge did not step into the shoes of the prosecutor in proving the elements that the prosecutor wasn't able to prove at the preliminary examination?
I don't find that the judge stepped into the shoes of the prosecutor. I think the judge asked questions to clarify the evidence on the record to see if there's enough evidence to bind over on the charges. That is my decision.
Okay, like I said, I just want to be as clear as I can so I can, determine what my next steps are.
That's fine. And whatever you do is fine. And if the Court of Appeal says I'm wrong, then I will learn something.
Yes, ma'am.
All right.
And that's, of course, with all due respect. I don't want you to think that I'm, questioning your judgment or whatever.
You have a right to advocate for your client, and I understand that.
Yes.
But the decision of the court is that the carrying a concealed weapon count is dismissed.
Yes,
That
ma'am.
was squashed. So there should be an amended information done.
Okay, thank you.
Okay, you're welcome.
We need a pre-trial date. You need another date.
Let's see. Was this the final conference?
Let me look at the calendar. Oh, I just have it written out the motion hearing date. It's probably the final conference. Yeah.
Probably is. So based on what the court has done, I don't know what the people are gonna do with respect to an offer. So we need to give you a new date.
Yes, ma'am.
Or possibly a new offer. Give me a pretrial date. How many do we have on May 7th now, Madam Clerk?
14.
Okay, let's do May 7th.
So I have 2 in-person exams on May 7th.
Okay. Is May 7th a Friday, Madam Clerk?
It is.
Okay, this is a 20 case. What's the following? Excuse me, the following Wednesday.
The 12th.
Let's do May 12th.
I have an in-person in Inkster at 10 a.m. on the 12th.
14.
The 14th.
14. Okay, 14th.
Okay. Please, Madam Prosecutor, if there's going to be a new offer, get that to defense counsel well in advance of May 14th so he can talk with his client, make a determination as to whether his client can take that offer on May 14th or whether we're going to trial.
Yes, Judge, I'll get it to my docket attorney right after we finish today.
Okay, thank you. This matter is concluded. Mr. Wilkerson,
Thank you so much. Have a great day.
You too. All right, we're down. We're getting there. Who has the phone?
That's the segregation.
Goodness. Is there any guard or anybody there near you?
Oh, in the bubble.
Okay, can they hear me?
No.
Okay, I wanted to see if they did it. Mr. Tucson, are you back?
Back, Your Honor. Thank you.
Okay, let's go ahead and call, now, as I indicated, well, I'll deal with it once we call it. Madam Clerk, call Brock and Wilson.
Sure. These are case numbers. 196331, defendant number 1, Anthony Brock, defendant number 2, Darnell Wilson. Both scheduled pretrials. Appearances for the record, please.
Morning, Your Honor. Sunita Dadamani on behalf of the people.
Morning.
Judge, good morning. May it please this most honorable court, Vincent J. Toussaint, on behalf of Mr. Anthony Brock, who appears today by Zoom video teleconferencing in IBC segregation and consents to having this hearing heard by Zoom.
Good morning. Good morning, Mr. Brock.
Good morning. Good morning, Your Honor. Evan Callanan, P30564, on behalf of Mr. Darnell Wilson, who appears via video conferencing from MDOC.
All right. Good morning, Mr. Callanan, and good morning, Mr. Brock and Mr. Wilson.
Morning. Morning.
All right. As I indicated, the court is at home and not in chambers. And so I know this, I believe you have to remind me, is this?
Absolutely, Judge. Judge, we have settled a pretrial today to have our trial readiness forms in and to have everything all set. I did deliver both packets for both defendants to your clerk. She has received them, she has indicated, and we are ready to be placed in the trial queue, Judge. All negotiations are finished. There is nothing further to do except get a trial date.
Okay, okay, I think she did send it to me. Hold on one second. Not only am I using the laptop, I'm also using the phone. Okay. All right.
We estimate this will take about 2 weeks and that we will have roughly 23 to 25 witnesses.
Okay, witness list have been filed?
Yes, Judge. And they are attached with the trial readiness forms, as well as the information, as well as the verdict form, as well as the jury instructions.
Okay, and all motions have been disposed of. We're not, everything is complete, correct?
That's correct, Judge. We will need one jury in this case, and that has already been decided.
Okay. All right. So now that I know everything is complete on the trial readiness form, we will send this to court administration. And once we get a date, we will alert the parties of when that will be. You said about 2 weeks to try this case?
That's what I believe, Judge.
And we believe that as well.
There's
Okay.
19 counts and some, so.
Yeah.
19 counts, man. Yeah.
I'm sorry, are the defendants talking? Because I keep hearing voices.
Defendants, I know you can't talk while we're having the proceedings. It's just for you to hear what's going on. If you want to talk to your attorney, we could put you in the breakout room, but you can't talk during the proceedings. Okay. All right. So just Mr. Brock and Mr. Wilson, so you will understand what's going on here. As you know, there is a pandemic and the numbers in Michigan, I don't know how much information you get in there, are going up even higher. And because of that, we're back to phase 1. We're not doing any in-person jury trials right now. We're only doing in-person bench trials, sentencing, hearings, and those can only have 10 people in the courtroom at a time. So with respect to jury trials, we have to send a jury trial readiness to the court administration, who then coordinates jury trials among all the judges that are in Frank Murphy. So it's not just one court. You have to do all of them. So I'm just going to let you know this is probably going to be a while because we were on track to do 1 or 2 jury trials a week, which is really not even going to tip the iceberg considering all the trials we have that are backed up. We are starting with people who are incarcerated first, but now there aren't any trials going at all because of the number. So this will go and it will get in the queue and we will wait for a date. But I'm just telling you, you know, if it hits summer and you haven't heard anything, that's quite possible. It might not even be to the fall. It might not be to the winter. I don't know because we just aren't doing any jury trials right now. So don't think it's strange. We haven't forgotten about you. You are in the queue now. Now that we received the trial readiness form, it will be submitted today. You will be in the queue. Once we get a date, you'll get that date, okay?
Yes,
Second
ma'am.
date is June 11th.
Okay, so we have a review date on June the 11th. And we'll see if we've heard anything from court administration by that time. By that time, we'll probably see what's going on with the numbers in Michigan, and we can let you know if jury trials are back on track. And I'm sure we're not doing a jury trial over Zoom, right? This is in person.
Not at all, Your Honor.
Yeah, there's no way in the world.
There's no way.
Exactly. Not based on what you're telling me. So, okay. So we'll be back on June 11th as a review date. And at that point, we can let the defendants know if, we're doing trials again and if we have any date from court administration. Okay?
Are you going to writ them back or are they going to be waived, Judge?
Well, let's ask their defense counsel and the defendants. Do you all want them written back just to get that information, or do you want to give it to them, or would you like them here?
Always like to have my client here when we are doing anything on his.
Okay. Well, that's
I'm in
good.
agreement with that, Judge.
Okay, so we'll rid them because I can always put you in a breakout room with them and you can talk to them. I'm not sure how you talk to them right now, but that gives you another opportunity.
Well, I intend on seeing Mr. Wilson in the next week.
Okay. All right. So we will writ them out, Madam Clerk. You can let Hope know that we'll writ them out on June 11th. Okay.
Thank you, Judge.
Thank you.
Thank you very much, Your Honor.
Thank
Hope
you, Your
you feel
Honor.
better,
Have a great
Judge.
day.
You get well, Your Honor, and get well soon, okay?
Thank you.
Yeah.
Thank you, Judge.
Thank you.
Take care, Judge.
Now.
Okay. Now, we gotta be towards the end of this. My goodness.
Is there counsel on the line yet for Mr. Claypool? Has counsel arrived?
Your Honor, this is Attorney Michael Woodyard. I was asked to zoom in on a case where a client was allowed to, a lawyer was allowed to withdraw. I don't know if that's the case.
That's Claypool.
That's Claypool.
I'm ready, Judge.
Okay, would you like to go in the breakout room with Mr. Claypool?
Yes, please, if the court would permit.
Oh, wait a minute. Let me try this again. Right, we are going to assign Mr. Claypool, Mr. William. Mr. William. Mr. Claypool. Okay, you should get an invitation shortly. All right. We have the Mr. Kuja. Are we ready on your case?
Yes, Judge, we're ready. If there's a Miss Slayton, I'm going to stand in for her lawyer. I don't know if she's called in or not.
Okay. This is a two-defendant case,
Yes, it was, Judge.
and there's a plea for both defendants.
It's a sentence. They both pled.
I mean, a sentence for both defendants.
Yes, Your Honor.
Okay, I think they probably emailed me. Hold on a second. All right, I see the pre-sentence report as to Ms. Baker. Okay, there was a sentence agreement with respect to Ms. Baker.
Yes, Judge.
Okay, who's the other defendant?
Her name is Kiara Slayton.
All right. Let's see, do I have the pre-sentence report for her? I believe I do. Let's see. This is Such a crazy way to do things. Ms. Slayton. Okay, I'm looking at Ms. Slayton's sentence report as well. There's no plea agreement with respect to Ms. Slayton?
Correct.
Okay, I'm not gonna be able to open them up at the same time because I only have one phone. So,
Judge, I will say it might be easier to call them separately because the
yeah, we're gonna have to. Because I can't, I have to look at it on my phone. Unless Mr. Kuja knows how to split the screen.
I don't. Sorry, Judge.
It's a lot going on here. So let me go to, they emailed me so much stuff. I'll have to go through and find out where everything is. Sentencing. It's not. Hold on one second. I know my JA sent me the sentencing script. And
You need something from the court, Judge?
no, I need to find the sentencing script that she sent me because I've gotten so many emails and they don't have subjects on them. Ms. Hope, you didn't put subjects on them, so I'm just kind of scrolling through.
Judge, I apologize. I was moving fast this morning. I will resend it right now.
Yes, please. I can't find it. All right, we could do Miss Baker first. Oh, as soon as I get the sentencing. Oh my goodness, let me see. Is somebody mute? Also, if I can mute. Oh, good, I was able to mute him. Let's see. Can you all hear me?
Yes.
Okay. All right. As soon as I get the email, if we can proceed, I think we'll do Miss Baker first.
It's coming in right now, Judge.
Okay. Okay, I think I just got it. Okay, Madam Clerk, you can call Ms. Baker's case.
This is case number 202370, defendant number 2, people of the state of Michigan versus Deja Baker. Scheduled sentencing. Appearances for the record, please.
Good morning, Your Honor. Andrea McCray, on behalf of the people, P number 83698.
And good morning, Your Honor. Jamil Kuja appearing on behalf of Ms. Deja Baker.
Ms. Baker, state your name for the record.
Deja Baker.
All right, this is the date, time, and place set for sentencing in this matter. Ms. Baker, do you consent to be sentenced over Zoom?
Yes.
Okay, let me go back to the report. Okay. All right, it looks like there was a plea agreement in this matter in which Ms. Baker pled to count 1, financial transactions, device, illegal sale or use of 4-year max And count 2, financial transaction device dealing retaining without consent, which is also a 4-year max. There was a second agreement, no charge reduction. Count 1, financial transaction delivery device illegal use sale. And count 2, financial transaction device dealing retaining without consent. People agreed to dismiss counts 8, 9, 10, 11, 12, and 13. Consent to HIDA. 1,000 towards restitution paid by date of sentencing. Remainder of $3,640.50 restitution. Total owed to be paid joint and severally over an 18-month probationary period, and any terms, costs, and conditions determined by the court. Is that correct, Madam Prosecutor?
Yes, Judge.
So does Ms. Baker have her $1,000 that she is supposed to be tendering today?
She does, Judge. She just didn't know how to pay it because the court's closed. She wasn't sure where she can pay it, but she does have it, she says.
Ms. Schoen,
Yes, Judge.
do you know how she should pay her $1,000?
I will put it in chat. I'm gonna look it up and I'll put it in chat for the attorney.
Okay. Okay, have the parties had an opportunity to review the body of the pre-sentence investigation report?
Yes.
Are there any changes, deletions, or corrections?
So Judge, on behalf of the people, there are to the body of the report, under Department of Corrections recommendation, that should be page 2, number 9. I think it's just a typo. The victim assessment amount is 1,300. I'm pretty sure it's just supposed to be 130.
Okay, we got to go a little slower because I'm looking at a phone.
Okay, for sure. Okay, so I'm looking at Department of Corrections recommendation. It should be the second page after the cover page.
Okay, wait a minute. For some reason, I don't have a second page. I got 2 of 2, and that the second page is the one that's titled Department of Corrections recommendation. You said it's on the second page. Is that correct?
So if you're looking at Department of Corrections recommendation, if you go down to number 9, it is page 2, but maybe on your copy it's page 1.
Okay, I do have number 9.
Okay, the amount I think is just 130, not 1,300.
Oh, okay. The amount for crime victims assessment should be an amount of $130. That's correct. And it's showing 1,300. That needs to be stricken. No objection by the defense, I assume.
None to that, Judge.
Okay, on the PSI, I'm gonna have to make these changes when I get in, so I'm writing down notes. Okay, anything else?
So Judge, this has to do with sentencing guidelines, but page number 2 under evaluation and plan. So page number 2 under evaluation and plan, the first 2 sentences list the sentencing guidelines to be 0 to 3 months, and I think they should be 0 to 6, but perhaps that's
Hold
something we can
Hold on, let me just deal with the body of the report right now.
Sure.
Mr. Kujo, anything else with respect to the body of the report?
Judge, on that same page that the prosecutor was referencing, but
Under Department of Corrections recommendations?
yes, Judge.
Okay.
On paragraph 8, they say you must pay restitution in the amount of $4,640, but the amount of restitution that they put in the body of the report is $3,640.50, and so the $1,000 should be deducted from that.
Well, Judge, because we don't have proof of that yet, I would ask that the amount still stay the same. And of course, when it's paid, it'll be reduced, but I would feel uncomfortable reducing it.
No, what I'm saying is that the total amount is the 3,600, and then once it's paid, now it would get reduced to 2,600.
Okay, so he's saying that the total amount is inaccurate. He's saying that the total amount is actually $3,640.50, and she had to pay $1,000 today, and so her amount should be $2,640.50. Is that correct? What you're saying?
Yes, Judge, because the victim's impact statement says that they're seeking restitution in the amount of $3,640.50.
Okay, I see what you're saying. You understand that, Ms. McCray?
Yes, but I still do not feel comfortable.
Oh, Ms. McCray, I think you're missing what we're saying. We're not taking off the fact that she has to pay 1,000. What he's saying is the victim's impact statement says the total restitution is 3640.50, regardless of when 1,000 has to be paid of the remaining. The total is 3640.50, not 4640.
Right. I have no disagreement with that.
Okay, so what should be changed is it should say you must pay restitution in the amount of 3640.50. 1,000 is supposed to be due today, and the remaining should be 2640.50. So we're not taking off the 1,000, but the total is wrong at the top.
Right. I have no problem with that.
Okay. All right, so that'll be changed. This is in number 8.
And
the total should have been 3640.50 with 1,000 paid at sentencing. And the remaining total should be 2,640.50. If that 1,000 isn't paid, then it's still, the total is still $3,640.50, but he says she has it. Okay, anything else, Mr. Kuja?
yes, Judge, because there's a co-defendant, they're saying joint and several.
Right.
I just want to, for clarification, the $1,000 that she's paying is only going to come off of her half, right? I mean, they're not going to take that 1,000 and then divide it by 2 between her and the co-defendant.
Well,
right?
when they joint and severally, they just mean they're both responsible for the full amount. So, I mean, you know, they need to work together if they want to split it, but I don't know if that they have it divided by the defendants. Is this the same amount of restitution on the other defendants' pre-sentence report?
It should be, Judge. It doesn't say so. It says to be TBD, but it should be the
Same amount.
Okay, so
case.
joint and several just means they're both responsible. They
With the
both
court-
for the full amount. There's no, you know.
Judge, this is the actual victim in the case was reimbursed her credit, you know, what was charged on her credit card, but Von Mar is seeking the $3,600. Would the court, just so it's simpler, divide it by 2 and just assess, you know, 1,800 and change against Ms. Baker and then 1,800 and change against Ms. Slayton, so that each one of them is responsible for their own half?
Well, it's joint and several, and which really means, as far as I understand it, it's due no matter who pays it, that they're both responsible for it. I don't think the court can separate it that way. I think it's joint and several, whatever the legal definition of that is, which I believe means that they both are just responsible for it. So I'm just gonna leave the wording as it is.
Right. Thank you, Judge.
Okay. I assume her co-defendant is somebody that she knows. I mean, you know, they need to work together, but it's got to be paid for both of them. They got 18 months to pay it. Well, the other defendant doesn't even have a sentence agreement. So on Ms. Baker's sentence agreement, it says she has 18 months to pay the balance, correct?
Correct, Judge.
Well, I'll tell you what I'll do. Since there is no sentence agreement on the co-defendant, those are the conditions I'll require on the co-defendants. So she'll have to pay based on what the court is going to tell her, since there's no sentence agreement. Okay.
Okay. Thank you, Your Honor.
All right. Anything else as to the body of the report?
No, Judge.
All right. There's some issue with respect to the guidelines.
Yes, Judge.
Okay. What's that?
So PRV 7 should be 10.
Okay. And they have it as 0.
Yes, Your Honor.
All right. Defense.
Isn't PRV 7 if she was on probation or something at the time?
That's
I
PRV.
don't think she was.
That's PRV.
7 accounts for count 2.
Oh, okay. All right. Yeah, you're right. Okay. All right.
So that means the PRVs go to 17 instead of 7.
Correct, Your Honor.
Any objection, defense?
No, Your Honor.
Okay, so the PRV will be changed to 10, which makes the overall total 17. And then does that change the PRV level?
To C, Your Honor, yes.
Okay. What about for the OVs?
OV 12 should be 10.
What's OV 12?
OV 12 is contemporaneous felonious acts. That would account for the criminal acts that were dismissed.
Okay. OV 12 should be 10.
Yeah.
Any objection, defense?
Yes, Judge, I think because she got scored for PRV 7, you can also score OV 12.
That's not true. It's just for OV 11.
I've never read that before. 12 and 13 cannot be scored together, but I've never heard of PRV 7 and OV 12 not being scored together.
That wouldn't even make sense, Judge, because OV 12 deals with acts.
PRV 7 deals with a prior record. OV 12 deals with what she's currently charged with.
Well,
So that PRV 7 deals with, PRV 7 deals with what she's charged with, more than one charge.
Conviction.
Right. And OV 12 deals with contemporaneous charges, correct?
Yes.
Is that within a 5-year period, or is that OV 13? I don't have the book.
That's OV, the OV 13. That's the OV 12 is within 24 hours. The yeah.
OV 13 is within 5 years.
Right.
All right.
Okay,
I don't
we're talking
think
OV 12.
Yes,
Judge, then here's my objection to that is it's talking about other crimes that occurred within 24 hours, but this series of credit card charges, they didn't occur within 24 hours of each other. This is, for whatever reason, they went to the same store multiple times using the same credit card, but it was weeks apart, and that's how they were caught.
So on the information, is it a day range, like a day's range on the information? Does it say like between the period of?
Yes.
What is it, from the period of what?
April 29, 2019 to July 6, 2019.
All right. So wouldn't it fit into OV 13 more so than it would be OV 12 then?
So if I personally don't think so, because I always but you know, I could definitely see that argument. Let me look to property.
Because if OV 12 requires within 24 hours, how many charges do we have within the 24-hour period?
So Judge, I think the way I look at OV 12 is that you take the information with that date and then with date or dates, and then you go within 24 hours of that. But I also understand what Your Honor is saying. And so let me see if so if we want to do OV 13, okay, so that would be, I think that's going to give more points. Let me see.
Because I think OV 13 lists a certain amount of crimes within the 5-year period, either against persons or against property.
Yeah, so what I'll agree to that, Judge. We can do 10 points for, if you want to do 0 for OV 12, and then we can do 10 for OV 13.
And it'll be 10 for OV 13 for what?
So
go ahead.
The offense was part of a felonious criminal activity involving a combination of 3 or more crimes against a person or property.
Okay, and all these were property crimes or person crimes?
Property.
Okay, and that's 10 points.
But Judge, now we don't have three, we have 2, right? Because you've got
you have count 8, all the ones that you dismissed.
Wait a minute, it still goes against, it doesn't matter that the prosecution gave you a plea in which is less than 3, but there's still 3 or more crimes during a 5-year period, correct?
Yes.
That's not your, Mr. Kuja, you objecting to that?
Yes, Judge, because they're all the same act. Because they go to a store, I believe 2 or 3 times, right? And they charge them. They use the credit card that's stolen, so they charge them with possession of the stolen credit card, use of the stolen credit card, and retail fraud.
Right.
And it's all one act. It's not contemporaneous act. It's not separate act. It's one act that falls under, violates 3 statutes.
No, because
It's not like a pattern.
those acts were done on different days. So if they were done on different days, those are 3 different acts in which they use stolen credit cards. So those are three different transactions and occurrences. They're not, it's not the same thing.
No, there's only two different dates. There's a April, let me look at the information, Judge. There's a April 26th of 2019. They go into the store, they use a stolen credit card. Then they go back to the store on July 6th of 2019 and use the same stolen credit card again, right?
Okay.
But each time they only did one thing, which was go in two separate times and use the credit card. And there's like 12 counts on the information because they charge them with possessing a stolen credit card, using a stolen credit card, retail fraud because it took place in a store. But the credit card itself was only swiped twice. So that's why I'm saying this is not multiple. There's only two acts, even though there's a violation of like 12 statutes here. It's only two acts that they committed.
Read the OV 13, and I do not have my book here. Read the definition for OV 13.
I'm reading, it says the offense was a part of felonious criminal activity involving a combination of three or more crimes against a person or property, or a violation of, and it lists a bunch of statutes.
Judge,
So
the
three or more crimes. We have three or more crimes.
Okay.
We may not have more, we only have two dates, but we do have three or more crimes because they were charged with different crimes with respect to those two acts of going in that store 2 times. They had more than 3 counts, didn't they?
Yes.
So that's that's 3 or more crimes. So
Okay,
yeah,
all right, I see what you're saying, Judge.
yeah, the defense objection is noted, but the court is going to score 10 points for OV 13. Okay. So now does that change that makes OV what? The total OV is 15?
Yes, Your Honor.
Does that change anything?
OB level 2 and 0 to 6 would be the minimum.
All right, so it really doesn't change any much anyway. It's 0 to 6 is the guidelines. All right, counsel, 0 to 6, defense counsel.
Sure, Judge.
And your objections are noted.
Thank you.
Okay, but there's a sentence agreement anyway. So, anything else you'd like to say or anything else? Are we done with the guidelines?
Yes, Judge, that just changes on the body of the report. It says it lists 0 to 3. It should be changed to 0 to 6. I'm looking at the second page of the evaluation and plan, first paragraph.
That it should be, the level should be changed to 0 to 6.
Yeah, and it is in the first sentence and the second sentence.
Okay, I got that. All right, anything else on behalf of the defense? The people?
No, Judge, just at this time, we would move to dismiss counts 8, 9, 10, 11, 12, and 13.
All right, no objection, I'm assuming, defense?
No objection to that one, Your Honor.
Okay, and defense, anything else you'd like to say on behalf of your client?
No, Your Honor, thank you.
Okay. The court will sentence Ms. Baker pursuant to the sentence agreement. Let me get back to it because I had to go to something else. Technology. I will be glad when we are back. Okay, so the court will sentence Ms. Baker pursuant to the sentence agreement, which is 18 months probation. She has to pay the $1,000 at the time of sentencing. There is a consultant item, correct? And will be placed item. The court costs and fees. Can you indicate court costs and fees?
What was that, Your Honor?
I was asking Madam Clerk to indicate court costs and fees.
It's the regular cost, $1,300, $130, $68, $400.
Okay, so $1,300. I need you to list them all out, Madam.
I'm sorry, $1,300 is the cost, court cost.
Okay.
$400 is the attorney fee.
Mhm.
$130 crime victim, and $68 state minimum.
Okay. Anything defense regarding the court costs?
Your Honor, I just note that she is indigent. Um, to take that into account, the court would reduce any of the costs and fines.
All right, Ms. Baker, are you working?
No, I have found a job, but I'm trying to obtain my license so I can get back and forth from work.
Your vehicle license?
Yes.
Where did you find a job?
It's in Livonia, but I haven't started it yet. It's at Amazon.
Okay. All right. So, well, can you take a bus there?
No, it's kind of like far out in Livonia. Well, I don't know. I never took the bus before, so.
You should probably check into it. When are you supposed to start?
He didn't tell me, and I think they required personal transportation.
All right. Well, Ms. Baker, I would suggest that you do what's necessary to get that together so that you don't find yourself back here. You need a job, okay?
Okay.
All right, the court is gonna reduce your court costs from 1,300 to 300. And I'm gonna waive your attorney fees, okay?
Okay.
I need you to make the effort to get a job so that you don't find yourself in this position again. You're also under HIDA. Do you understand what that means, Ms. Baker?
Yes.
Okay, so during this 18 months time, stay out of trouble and get your restitution paid off, which is another reason you need a job, so that you will not have a criminal record at the end of your 18-month probation. It can't be said how important that is, because it's much easier to find a job when you don't have a criminal record. Do you understand?
Yes.
And places to live, all that kind of stuff. Criminal records create problems with all of that. So I want to see you not have a criminal record, okay?
Yes, I appreciate it.
Okay. Appellate rights. I need to give her. Oh, wait a minute. She's HIDA. So we're not doing appellate rights because she's HIDA, correct?
Correct, Judge.
All right. So you need to call probation when you get off the phone, when you get off this call. And the number is 313 45. I think it's 4600.
313-456-4100.
4600.
Okay.
Okay. Anything else we need to tell Ms. Baker?
Your Honor, I did forward her the email with the website where she can go and make her payments for her costs and fines. So it was put in the chat by your clerk, and then Ms. Baker, I forwarded it to you in an email, so you have it for your records, okay?
Okay.
All right, Ms. Baker, so you have the information that's on the record. Make sure you pay it, okay?
Okay.
All right. All right, have a good day, Ms. Baker.
You too. Thank you.
All right, good luck.
You too.
Okay, now we need to do Miss who?
Miss Slayton, Judge. Oh, you know what? She just sent the text message that her phone died, so.
All right, well, we'll go to Miss Bridges then.
Or I guess she's back, but she said she's in the waiting room. I'm not sure.
She's in the waiting room. Hold on. Let's see. We do have somebody in the waiting room. That may be her.
Yeah.
Is that Miss Slater?
I think that's her, Judge.
Is that Miss Slater?
Yes.
Okay. All right, go ahead, Madam Clerk.
This is case number 202370, defendant number 1, people of the state of Michigan versus Kiara Slayton, also scheduled sentencing. Appearances for the record, please.
Good morning, Your Honor. I'm Diane McCray, appearing on behalf of the people, P number 83698.
And good morning, Your Honor. Jamil Kuja appearing on behalf of Miss Slater, and I'm standing in for her attorney of record, Christopher Kessel. That's with her permission, correct, ma'am?
Yes,
All right, is your name Slater or Slayton?
Slayton.
Oh,
We want to pronounce it correctly, okay? Her name is Slayton. All right, this is the day and time and place set for sentencing of Miss Slayton. Miss Slayton, do you consent to be sentenced over Zoom?
Yes,
Okay, and have you had an opportunity to go over the pre-sentence report with Mr. Kuja?
yes,
All right. And Mr. Kuja and Ms. McCray, have you had an opportunity to go over the pre-sentence report?
Yes.
yes,
Right.
Judge.
Any corrections, deletions, or additions to the body of the report?
Judge, so on, I have two corrections. On the cover page, she is convicted of 2 misdemeanors. So misdemeanor should say 2.
Oh, wait a minute. Okay, where it says 1 on the
Mhm.
prior record.
Yes, Your Honor.
Mr. Kuja?
I don't have her lien or anything, so I mean,
It's in the report.
oh, okay, in the report, yeah, then yes, Judge, no objection.
All right, Ms. Slayton, you were convicted of 2 misdemeanors previously?
yes.
Okay, all right, so it should say 2. Anything else?
Yes, Judge. So under Department of Corrections recommendation, I'm not sure which page that is for you. For me, it's page number 2. Under number 2, it says restitution to BD. I think we're doing the 2,000, right, for this one?
The $3,640.
Well, she still has the total, because it's joint and several, so it's still the full total.
Okay, sure.
But you know, when I sentence her, I'll tell her what she needs to do with respect to paying it. But yeah, the total should be, it should not, the total is still 3,000, so that needs to be changed. The total was $3,640.50, correct?
Yes.
Yes, Judge.
Okay, so that'll be amended, and that's under number 2. Okay, anything else?
Not with respect to the body, Your Honor.
Nothing.
Nothing. Miss Slayton, is everything in the pre-sentence report as you saw it true and accurate now that we've amended the misdemeanors to 2?
Yes.
Okay, now let's go to the sentencing guidelines. Any issues with the sentencing guidelines?
Yes, Judge. I have issues with OV 13 and OV 16.
All right, let's do the PRVs first. Any issues with the PRVs?
No.
PRVs are 5. Is that correct, Mr. Kuja?
Yes, Judge.
All right, now OVs, Madam Prosecutor.
Yeah, OV 13, I believe, should be 10. And that would just mirror the discussion we had previously for the co-defendant.
Okay, the court would change OV 13 to 10. Any objection, Mr. Kuja?
Judge, I believe or you know what, no objection, Judge.
Okay, and what else, Ms. McCray?
OV 16 should be 5. That's the amount of restitution, and that would just account for the 3,000.
Oh, okay. OV 16 should be 5 based on the restitution amount.
Yes.
No
Any
objection.
objection, Ms. Kuja? Okay, so that changes the OV level to what?
15.
16?
15, Your Honor, 15.
Oh, 15, okay. And does that change the overall level?
Yes, Your Honor, to 2.
Okay, does that change the sentencing guidelines?
Yes, 0 to 6.
Okay. Any objection from the defense?
No objection, Your Honor.
Okay. Anything else?
No, Your Honor, not on behalf of the people.
All right. There's nothing to dismiss on behalf of the people.
There is, Judge. At this time, the people would move to dismiss counts 2, 3, 4, 5, 6, and 7.
No objection, I take it,
Oh,
defense.
no objection, Judge.
All right, and anything else on behalf of the people?
No, Judge.
Mr. Kuja, anything you want to say on behalf of Ms. Slayton?
Your Honor, just that I'd ask you to sentence her to a term of probation so she can pay her back the restitution with her co-defendant.
Okay, is she getting HIDA as well?
She's too old, Judge. She's 25. Her co-defendant was just under 24, so she was able to get it.
Oh, okay, all right. All right, Ms. Slayton, I am going back to, 1 second. Keep closing out things and opening up things. I'm looking for. I just got this. All right, Ms. Slayton, the court is going to sentence you to 18 months probation. And the amount of restitution of $3,640.50 is applied in your case. It's joint and several, but what I'm going to indicate is that you need to make efforts to pay half of that, which is $1,820.25. However, keep in mind that both of you all know each other, so you should work together. So your part of the restitution will be $1,820.25. But keep in mind, it is joint and several, which means technically both of you are responsible for the full amount, but your co-defendant has already paid $1,000. So I think it's only fair that you try to pay some of it as well. Understand?
Yes.
Okay. What else are we doing? The court costs are 130 crime victims, $68 state court costs, 1,300 court costs, state minimum, $68 state minimum, $1,300 court costs, and $400 attorney fees. Are you working, Ms. Slayton? Are you working?
Not at the moment.
Okay. Are you actively seeking a job?
Yes.
Okay. I just realized that on the other one, I didn't go through everything on this report. So I'm gonna have to do it on this one. We may have to call Ms. Baker back. Hold on 1 second. This is so cumbersome. Okay. All right, Ms. Slayton. 18 months probation in which you have to pay the restitution. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours per week. You must engage in an alternative program approved by the field agent. You must provide ongoing verification of employment or alternative program to the field agent. You shall not give reason to be terminated or voluntarily terminate your employment or alternative program unless you first obtain written permission from the field agent. You must pay restitution in the amount of, as I said, is $3,640.50 joint and severally. But I am saying you should pay $1,820.25. There's victims assessment, crime victims assessment, amount of $130. You must pay supervision fee of $30 per month. You must pay $1,300 as court costs. I am going to reduce that down to $300. And your attorney fees are supposed to be $400. I'll waive those. So you're on 18-month probation. You, as part of your probation, you must find and maintain the employment of at least 30 hours a week. You understand, Ms. Slayton?
I do, but you do know that there is like the COVID going around, and I just lost my grandfather to COVID, and I also just found out that another one of my family members has COVID as well, and I do have 2 children.
I understand that you have 18 months. That's a year and a half.
Okay.
Because you got restitution to pay back as well. Your co-defendant looks like secured a job at Amazon. Is it Amazon? Is that what she said, Mr. Kuja?
It is, Judge.
Yes, Amazon is hiring constantly. So maybe that's a place that you should look to apply. Okay? But there are positions out there. I understand it's a pandemic, but there are people working because people still gotta work and pay their bills. Understand?
Yeah, I'm not saying that I don't have savings or, I'm unable to pay my restitution. Even though if it's a monthly payment, I know I can incorporate that in whatever I have going on monthly.
Okay, well, I just don't want to see you back here on another charge. So, what I'm saying, we don't want to start a long, lengthy criminal history because that just makes your life harder. You understand?
Mm-hmm.
All right, so you got 18 months, and during that time, you need to make legitimate efforts to find and maintain a job at 30 hours a week. Okay?
Okay.
I have to advise you of your appellate rights. So let me go back. Okay, it's my duty to advise you that you have the right to request leave to appeal from the Court of Appeals to appeal your plea and sentence. If you're unable to afford an attorney to prepare a post-conviction motion or perfect an appeal, this court will appoint an attorney for you at public expense and will provide that attorney with such portion of the transcript as that attorney may require to prepare a motion or appeal. You are further advised that if you wish to file an appeal or motion, request for the appointment of an attorney must be made in writing and filed with this clerk of this court within 42 days of today's date. You will receive from this clerk, she will email your appellate rights form to your attorney. In this case, it will be Mr. Kuja, since he's representing you for the sentencing. Does Mr. Kuja have your permission to initial the form on your behalf, acknowledging your receipt of the form, Ms. Slayton?
Yes. And
this is the form you will file with the clerk of this court within 42 days of today's date if you wish to appeal and need to have a counsel appointed for you. If you do not wish to appeal, you do not need to send the form in. Okay, you also need to call probation when you hang up, Ms. Slayton. That number is 313. Do you have something to write with? Are you ready? Are you ready, Miss Slayton? You're on mute.
Yes.
313.
Mm-hmm.
456.
456.
Yeah. 4,600. It's 4,600, right, Madam Clerk?
Yes.
4,600.
Okay.
Okay. Anything else from council?
No, Your Honor. Thank you.
Okay, Mr. Kuja, I think you're gonna have to get Miss Baker back because I did not give her the requirements under probation, which I should have done.
You want me to tell her to get back on?
Yes.
Okay, I'll do that right now.
You're concluded, okay?
Okay.
Good luck to you. Bye-bye.
You too.
All right, is anyone on the line for Mr. Claypool?
Judge, I am Woodyard. I'm ready to go, Judge.
Okay. Can you call Mr. Claypool's case?
Case number 196312, People of the State of Michigan versus Tyvon Claypool, here for a pretrial and a new attorney. Appearances for the record, please.
Appearances?
Yes, I'm here, Tyvon Claypool.
Okay, Mr. Claypool. Is this your case, Ms. McCray?
It's not, Judge, but I'll stand in for Ms. Nersessian. I know she was here previously. Andrea McCray appearing on behalf of the people, P number 83698, standing in for the APA of record, Ms. Laura Nersessian.
And Your Honor, good morning to you and to your staff. Attorney Michael Woodyard, P number 64612. I have just been appointed to represent Mr. Claypool. I appear by Zoom without objection. I think Mr. Claypool does the same.
Okay, good. Mr. Claypool, you do not object to appearing by Zoom, correct?
No, ma'am.
Although it's a pretrial, so it's not really that big of a difference. All right, Mr. I know we have to give you an opportunity to get familiar with the case, Mr. Woodyard. What was this originally scheduled for, Ms. McCray?
This was originally scheduled for a pretrial.
Okay, is there an offer with respect to this case?
I am unaware of that, Your Honor. I can text Laura.
Oh, this is Laura's case, correct?
Yes, Your
Honor. Call to phone.
Your Honor, I would indicate that this case originated, there was a trial date actually scheduled in February of 2020. So this case has been around for a long time. It originated in August of 2019.
Yeah, we need to get this resolved. It's a 2019 case. See if you can get Ms. Nersessian on the line.
Okay, yeah, I'm texting her right now.
So she can give whatever information is necessary to Mr. Woodyard. And then I'm sure we're gonna have to pick another date anyway, but we need to kind of move.
Get a handle on things.
Yes.
Thank you.
All right, let me see.
And Your Honor, in the meantime, I'm also going to ask the court if it would order a pretrial services report for Mr. Claypool so that when we do come back, if it's a possible, we may address bond, specifically the tether.
Okay. The court will order pretrial services.
Thank you.
Okay, do we have Miss, while we're waiting on Miss Laura Nersessian, is that Miss Baker that's back on the phone?
Yes.
All right, Miss Baker, I neglected to give you when I did your sentencing. Because you're
Hold on.
Okay.
Recalling case number 202370, defendant number 2, Deja Baker, previously here for sentencing. Appearances for the record.
Good morning, Your Honor. Andrea McCray appearing on behalf of the people, P number 83698.
And Judge Jamil Kuja appearing on behalf of Ms. Baker.
Okay, Ms. Baker, previously when we did your sentencing, because you were a hider, you didn't get appeals rights. And so then I just closed it out, but you still should have gotten the information you need to know while you're on probation. So I just want to make sure you have that and we're on the record with that, okay?
Okay.
So I'm gonna go back to your pre-sentence report and make sure we put that on the record.
While you're doing that, so when I clicked on the link to go look for how I'm supposed to pay, it's a lot of districts on there. Am I supposed to go to like a 36th district, or is it back to the 16th district for Livonia?
We're the Third Circuit Court. Ms. Shawn, can you help her?
I have
Yes.
a payment website that you go to. Do you have a pencil, pen, something?
You can go ahead. I can go ahead and jot it down.
It's www.govpaynow. That's www.govpaynow. And your code is 5443.
Okay, thank you.
Okay, Ms. Baker. Hold on a second. Okay. As I indicated previously, it's 18 months probation We indicated what your restitution was, but you must comply with the requirements of drug testing directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing, and you must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures. You must present proper identification at the time of testing. You must not use or possess any controlled substance or drug paraphernalia unless prescribed for you by a licensed physician, or be with anyone you know to possess these items. And you must complete outpatient and residential substance abuse treatment when you're referred by the field agent. That's only if you are referred. It has on here that you must perform 150 hours of community service. That wasn't a part of her plea agreement, was it?
No.
Okay, the court is striking that. 150 hours of community service, that's not a part of your plea agreement. So it's strike that, which I'll do formally when I get in. You must complete substance abuse assessment when you are referred, if you're referred by the field agent, that's only if you are. But you must genuinely make efforts to find and maintain legitimate employment of a minimum of 30 hours a week, unless engaged in an alternative program approved by the field agent. You must provide ongoing verification of employment or alternative program to the field agent. And you shall not give reason to be terminated or voluntarily terminate your employment or alternative program unless you first obtain written permission by the field agent. And I already gave you your cost and your restitution. So I wanted to make sure you understood that's a part of your probation, those things that I've just written. And we've already talked about the fact that you need to get yourself together so that you can make it out to Amazon, okay?
Okay, but so I didn't know that I would have to drop. I just had to drop already, and that just finished. Because I don't have no way to keep getting back and forth. Is it weekly? Because mine was just weekly.
I don't know. You'd have to talk to the probation agent for all of that. They make those determinations.
Judge, would the court consider not ordering drug testing since the case really doesn't involve drugs at all?
And I don't do or do any drugs. Just got off of probation.
That's fine. The court will indicate that the Ms. Baker does not have to do drug testing.
Thank you.
Okay. All right.
I gave you the wrong website. I just called the cashier. It will reroute you, but I might as well give it to you.
Okay.
It's www.allpaid. www.allpaid. The code is still the same.
Okay. Thank you.
You're welcome.
Thank you, everybody. Have a good day.
You too. Have a good day. Have a good day, Ms. Baker.
You too.
All right. Bye-bye. Okay, now let's go back to Miss Narcessi's case. Can we call?
She's in the waiting room.
No, I'm here.
Oh.
Thank you, Judge. Sorry about that. Juggling 4 cases today.
No problem. Everybody's juggling something today. It is what it is. Okay, go ahead.
Judge, I understand that you requested to learn what the plea
Hold on.
offer.
Hold on, Ms. Narcessi. We're back on the record in case number 196312, defendant number 2, Tyvon Claypool, here for pretrial already in progress. Appearances for the record, please.
Thank you. Lauren Nersessian on behalf of the people, P67104.
And Your Honor, again, Michael Woodyard appearing on behalf of Mr. Claypool. 64612 is my P number.
All right, and Mr. Claypool, just state your name for the record.
Tyvon Claypool.
Okay, Miss Narcessian, since Mr. Woodyard, who I'm sure you know, just was appointed on this case, can you give us an update and tell us what's been going on? This is a 2019 case. I'm trying to figure out why this is still here.
Your Honor, I have made an offer. The last official offer was 1 count of CSC 3 with a sentence agreement of 5 to 15 years. The last conversations I was having with Mr. Schloff was to see if we could do better than that, and we were discussing further plea offers. That is when the breakdown occurred between Mr. Schloff and his client, and so we were in the, like I said, we were in the process of discussing further plea offer negotiations. So
okay, so the CSC 3 is that count 1?
Yes, Your Honor.
How many counts are on this? Because I don't have an information.
Oh, Your Honor, if I may have a second time. There is count 1, criminal sexual conduct in the first degree, that's accomplices. Count 2, criminal sexual conduct in the first degree, accomplices. Count, so we would be reducing count 1 to criminal sexual conduct in the third degree.
Okay, so that's a charge reduction.
Yes,
And then dismissing the remaining counts.
that's correct, Your Honor.
Is there a habitual?
No, Your Honor.
Okay, and the sentence agreement is 5 to 15.
That's correct, Your Honor.
What are his guidelines as charged?
Your Honor, I'm just trying to locate them.
Sure.
Oh, they are 108 to 180, Your Honor. So 9 to 15.
Okay. And the offer is 5, but as charged, guidelines start at 9 years.
Yes, Your Honor.
Okay, I'm sure that's the first time Mr. Woodard has heard that. He needs to speak with his client. And continuing the further negotiations. So, Mr. Woodard is just on the case. He needs to get discovery. I'm not sure if Mr. Schloff, who should be actually giving him the discovery. So, Mr. Woodard, you might try to make an attempt to see if you can get the discovery from Mr. Schloff. If that doesn't work, then we'll have to get the discovery. Is it already on evidence.com, Ms. Narcessian?
No, Your Honor, this evidence was turned over long before we were regularly using it.
Okay, all right.
Your Honor, I have actually, in the meantime, since being appointed about an hour ago, I spoke with Mr. Claypool in a breakout room. I texted Mr. Schloff and I emailed Ms. Narcessian. I think that for me and for Mr. Claypool, the best bet would be to set a comeback date and order a DSU report specifically related to the tether.
Okay, that we've already done.
Got it.
We're already gonna set a new date, but you still need to get discovery, and that's what the court is doing now.
I do, and I'm sure that that's all going to happen. I have great faith in my colleagues, and I'm confident we're going to be able to work that out.
Okay, so we're gonna give you a new date in May. And it will be, what day are we on in May now, Madam Clerk?
May, you still can do May 5th, May 14th, 19th, 21st.
May 5th?
I am good with all dates.
Mr. Woodard, what happened to Mr. Woodard?
Your Honor, you said the 15th, the 14th, or the 21st?
The 5th, the 5th. The 5th, or what else, Madam Clerk?
5th, the 14th, the 21st, the 19th.
May 5, Judge.
May 5?
Yeah, well, let's say, I apologize. I don't want to overpromise or underdeliver. Can we do it on the 19th, please?
That's fine. May 19th.
Thank you, Judge.
9 o'clock.
Thank you.
Okay, on May 19th, Ms. Narcessian, if there is a new offer that's being offered, make sure, Mr. Woodard, you all have that before May 19th, so the client will have had an opportunity to discuss that, and we'll know on the 19th whether he's taking a plea or we're proceeding to trial.
That sounds fine, Your Honor. I will do that absolutely.
Okay.
Thank you, Judge.
Thank you. Ms.
Thank
Madison.
you.
Mr. Claiborne, have a good day.
I'll call you, Mr.
Thank
Claypool.
you also.
Okay, Claypool, I'm sorry.
Thank you, Judge.
Bye-bye.
Be safe.
All right. Are we done?
What, Ms. Shaw?
Mr. Shepherd?
Yes, Mr.
Yes, ma'am. Madam Clerk and Your Honor, good morning. Today was set for my client and I arraignment on the information, and we've been in about 10 different judges' Zooms, and nobody can find Timothy McGough. Today was set for our arraignment. And so I'm yes, ma'am. I'm sorry.
I don't think he's on our
Timothy McGough, McGough. Birth date June 15th, 1990. And it was bound over March 26, Judge Giles.
And it's still sitting there. You need to contact 36th District. It never
Oh
made it
my,
over here.
oh my God. And
Okay.
36th District is sending me over. I'm sorry, Judge Baker. Thank you for your time.
That's okay. We tried. Yeah, you might have to, I don't know if people can walk in there or not, but
Well, we were both outside of the courtroom today only to be met by the deputies that said we're not doing in person.
right,
So,
'cause numbers.
yeah, yes, ma'am. But
Call this number for me. 224 224
yes, ma'am.
2526.
224-2526.
Maybe they can assist you. Just let
Yes,
them know
ma'am.
you're just trying to find out where the case is.
Okay, and then one last thing. If we cannot locate it, technically, is there in jeopardy of, or my client's in jeopardy of a warrant being, a CAPE being issued?
No, that would only happen if somebody called the case and wasn't.
And nobody, that's right, okay.
But you got to find out where it is.
Yes, ma'am, I'm tracking it down. Thank y'all, ladies, and have a good afternoon.
You too.
Thank you.
Miss Shawn,
Yes, ma'am.
what's going on with Osborne?
Osborne.
No, I'm sorry, not Osborne, your show call.
Oh, Mr. Lewis, Mr. Lewis was never was never given the date, so it's not his fault. We just need a new date for his show cause, and I'll make sure he gets it.
What date you want?
Whatever you got. It's a show cause, so it's not a warrant. It's not a big rush.
He has a pending case, Jerry Lewis, and it's set for, that's the Perkins Law Firm. Hold on, I'm trying to see when I think it's up in May. Let me see.
Yeah.
Yeah, so it's up May 19th.
Yeah, I was gonna give you May 26th.
Probably want to do the same day as the, right, if it's tracking, I don't know.
May what? Is tracking to what day?
May 19th. Yeah, sorry.
And you trust him to come to both of them? Okay, May 19th.
Thank you.
And I am waiting on Osborne, and that will be the docket. It's a review date. I don't know why, Judge, do you?
On Osborne?
Yeah.
What year is the case? 2020?
Yeah, it looks like it had a calendar conference, never had a final conference, but it has a review date. I don't know how that happens, but.
Is that one of the cases that didn't have a date that you might have went in and gave it a?
Oh, I see. This is a diversion case. I guess they were getting closed out today, but I don't have paperwork. I can adjourn it.
Oh, it's a diversion. Oh,
Yeah.
that means they were supposed to be here.
I don't even have paperwork, so.
So.
Oh, yes, I do. You can, no, this is the one. No, I already have it placing them on. His review date was scheduled for today.
So he was supposed to be closed out on diversion today?
Yeah, I'm not sure if it's a girl or a guy, but, no, it's a girl, but.
We need to know if they completed everything they were supposed to do while they were on diversion, though.
See, because this was so long ago before COVID, it was October. I don't know what's going on with it. So do you want me to reach out to Mr. Heath?
Yes. That's what I was
Okay,
getting ready to say. Call Heapy and we'll have to adjourn it.
Okay.
All right. Thank the Lord.
Then, I'm gonna call you on the phone, okay?
Okay. Everybody have a good day. We made it.
Okay, feel better, Judge.
Thank you.
Bye, everybody.